Good morning, sir. Can you see and hear us?
Yeah, thank you very much.
Thank you. In a moment, I'm going to call Mr. Altman King's counsel. Before I do so, I should say, because it's a Wednesday, there's a fire drill at 10 a.m., and so the feed will be cut for those that are following online.
All right, that's fine.
We'll all remain in the room.
Yeah.
Thank you. Yes, Mr. Altman, then, please.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Altman. As you know, my name is Jason Beer, and I ask questions on behalf of the inquiry. Can you give us your full name, please?
Brian Altman.
You should have in front of you a witness statement with the URN WITN 10350-100, which is 48 pages in length. Can you turn to the last page, please, page 48?
Yes.
Is that your signature?
It is.
And are the contents of it true to the best of your knowledge and belief?
They are.
Thank you very much for providing the witness statement. A copy of that will go up online on the inquiry's website. I'm not going to ask you questions about every part of it. Can I start, please, with your background? I think it's right that you were called to the bar in 1981. You
Yes.
took Silk in 2008. You served as Treasury Counsel between 1997 and 2013, the last 3 years of which you served as first Senior Treasury Counsel.
Yes.
At the material times we're concerned with, practice principally in criminal law, is that right?
Yes.
Thank you. Can I start, please, with the general approach that you took to the work that you did on behalf of the Post Office and your understanding of what they wanted from you? I think you ceased to be first Treasury Counsel at the end of June 2013, is that right?
Yes.
And you were instructed first by the Post Office the very next month in July.
That's correct.
When you were instructed, were you conscious then and afterwards that the Post Office wished to trade on your former status as first Senior Treasury Counsel?
I wasn't conscious of it, but I suppose I would say it didn't surprise me that they came to somebody with that history.
It didn't surprise you?
No.
Was there anything more than that?
No one ever said to me that we are instructing you because of your professional history.
Can we look at some documents
Yes,
that touch on this, please?
Yeah.
This issue, please. They come up on the screen. Poll 00192287. And the page 2, please, at the bottom. Thank you. This is an email chain that you're not party to. It's not to you, it's about you. And you'll see that it's dated the 18th of July 2013 between Gavin Matthews and the people set out on that distribution list. He was a partner at Bond Dickinson, who was then to instruct you.
Yes.
And he says to Susan Crichton, then General Counsel at the Post Office, here's a list of possible candidates. And you'll see, I think, Mark Ellison in a link on that web page, Ian Winter at Cloth Fair Chambers, you at 2 Bedford Row, Nick Purnell at Cloth Fair Chambers, and then a couple of others whose names aren't revealed by the URNs. I'll skip over the next paragraph, the from speaking to colleagues. It says, in the following paragraph, Brian Altman KC is interesting in that he is first Treasury Counsel, though his practice is not big on fraud cases. Simon Richardson, one of the solicitors, points out the possible attraction politically of having first Treasury Counsel on board. And then if we scroll up, please. And keep going. And keep going. And then just stop there. Gavin Matthews says he's spoken to the various clerks. and then under 2 Bedford Row, that's you. And then if we scroll down, please. There, at the top of the page, it says he, that's you, is no longer First Treasury Counsel from 1st of July, but he has the ear of the Director of Public Prosecution stroke Attorney General's Office. And then at the top of the page, if we keep going, please. There, stop. Mr. Flemington, one of the lawyers, says, how long is a few weeks in Brian's case? That's, I think, how long you're away for. And then his connections sound useful. Did anyone communicate to you upon instruction or otherwise that an attraction of having you as counsel would have a political dimension to it, in particular because you had the ear of the DPP or AG's office?
Never.
Were there any conversations that you had upon instruction or otherwise which, in which such sentiments were revealed to you?
Not once that I recall, no.
Would you understand why a client in the position of the Post Office in mid-2013, reviewing its past disclosure in criminal proceedings and possible miscarriages of justice, would see a political attraction of having you as its counsel?
No. I see the attraction of having me from a legal perspective as their counsel, but not politically.
A legal perspective because you're a very experienced prosecutor?
Yes.
Can you understand what they're talking about here at all? Your connections, your having the ear of the AG's office?
Well, I can see immediately from that email it was not me who made that representation, but I can see probably it was that attracted them.
You can see that what a belief that you had connections may have attracted them?
Oh, yes.
Did you ever use any such connections?
No.
Were you ever asked to use such connections?
Absolutely not.
Why do you think you can see why they would think that you having political connections would be useful?
I can't answer that, Mr. Beer, because I don't know what was in their mind, other than they may have thought that having somebody like me on the Post Office side instructed by them might give them some leverage in the political arena, but they were totally wrong if they did.
Thank you. That can come down. Can we look, please, at poll 406802? This is your review. It's an advice, but it's badged up in the tramlines as a review of the 19th of December 2013. And essentially, we're going to look at the detail later, but in summary, it consists of a review of the Post Office's investigatory and prosecutorial functions.
Yes.
And in particular, by looking backwards, advising the Post Office as to the continuation or non-continuation of those functions. Can we just look at page 40, please? And scroll down. And keep going and keep going. Thank you. Where you sign it off. Do you see that?
Yes.
Against your name and your chambers is footnote 33. And footnote 33 takes us down to the foot of the page, where it says that you're a practicing barrister. You were first appointed first senior Treasury Counsel to the Crown at the Central Criminal Court by the Attorney General in December 2010. You remained in post until the end of your tenure in June 2013. Appointed Junior Treasury Counsel in 1997 and Senior Treasury Counsel in 2002, appointed a Recorder of the Crown Court in 2003, Queen's Counsel in 2008, and were made a bencher of the Middle Temple in 2010. And then there's a link to your Chamber's web page. We asked you when you were preparing your witness statement whether this was your usual practice to footnote your name or some other part of written advices and set out a mini career history, and you said it wasn't your practice to do that, and you couldn't recall why you did it on this occasion.
I can't.
Correct. Can I suggest some possibilities. Was it that you knew or believed that your advice might be deployed outside the organisation?
I mean, I've thought about this because I was asked the question, and the interesting thing is there's an absence of a biography like this on the General Review.
Yes. I think I understand the point you're making there. You're saying if there was going to be a document that was to be deployed outside the organisation, it would be more likely to be the General Review.
Exactly. The only thing I can think of, but this is purely speculative, is that I was told or understood that this document would go to the board. But whether I was ever told there was a possibility this review would go outside the organisation, I can't say.
And if you were told that the documents would or might go to the board, why would that lead you to emphasising these points as you do in footnote 33?
Well, all I can imagine is that I was either asked or I felt it was appropriate for the board to know who was giving the advice, because the advice in this review was not all one way. One of the points I made, having trawled through all of the policies that Post Office and Royal Mail had before Post Office, or at the same time as Post Office, were that they were in a parlous, unsatisfactory state of affairs. So that could have been my thinking, but I'm speculating.
The essence of the advice that you gave was that the Post Office could properly carry on investigating and prosecuting crime on its own behalf.
On what I understood at that time, yes.
Did you think that overall conclusion might be deployed either outside the organisation or to the board, and therefore you needed to emphasise how senior and experienced you were?
Well, again, one of the thoughts I've had is they must have known who they were instructing anyway, so this was just, if you like, telling them what they already knew.
Yes, because we're 5 months in now.
Yeah. But I agree. I don't know the answers to that.
So for you, this is a curiosity too?
I can't remember. I mean, we're going back over a decade, and I can't remember, and I'm not going to say I was asked or if I felt it was a good idea to do it, or somewhere in between. I just don't know anymore.
Can we turn, please, to poll 0021 4820? And this is an exchange of emails, again, to which you were not party, in December 2014, so a couple of years further on. And the exchange is about what to say and what not to say to Nick Wallace in answer to questions that he was asking for the proposed broadcast of a second one-show piece. And can we go to page 4, please? At the foot of the page, please. Thank you. His question is at 6. We would like to put to you some opinion about the Post Office's approach to investigating and prosecuting sub-postmasters. We're in possession of an expert opinion from a professor in criminal justice, which implies Post Office's dual function as an investigator and prosecutor and its 300-year cultural history of using it against its agents is unique. That's not to say he thinks you're the only organisation with prosecuting powers, but that you have a unique culture of prosecuting your agents. He implies the approach lacks the checks and balances of a typical prosecution by the CPS. In his opinion, this creates a situation where miscarriages of justice are more likely to occur. I'll stop there.
Attention.
Thank you. Can I just check that you're still online, sir, and you can see and hear us?
Yes, I can. Thank you.
Thank you very much. Mr. Altman, I read the question, the Nick Wallace question, and then the answer, and I believe this is written in by Roderick Williams, one of the Post Office litigation lawyers. He says we should ask for this opinion. The privilege over it could have been waived. The expert cannot comment on what our culture is, at least not without speaking to us first. If this expert believes miscarriages of justice are likely to occur, he should set out for us the how and why, so that we can be sure they don't. Justice demands that. And then this, we've consulted former first Senior Treasury Counsel Brian Altman in connection with our prosecution practices. Brian's advice is privileged, and we cannot do anything which might waive that privilege. Please, therefore, do not do anything referencing Brian without clearing it with legal first. We've let Brian know that we may want to name check him, and this was contemplated when he was instructed. So two questions arising from that. Is it right that when you were instructed, you were told that you might, to use these words, be name-checked?
If I was, I've long forgotten it.
I.e. that your name might be deployed?
Yeah. I have absolutely no recollection of that.
And then later on, by December 2014, can you recall again being told that the Post Office, may want to deploy your name to the BBC?
I don't. I have absolutely no recollection of that either.
Was this an issue that ever arose to your recollection, that we want to say we, the Post Office, have got Brian Altman on board? He was first Senior Treasury Counsel. You can be assured that we're doing the right thing.
No, well, as I sit here now, I have absolutely no recollection of that.
Can we go forwards, please, to poll 0029 7951? We're going back to the time of your instruction. This is an exchange between Andrew Parsons, then a senior associate at Bond Dickinson, to Roderick Williams in the Post Office, a lawyer, and Gavin Matthews, the partner, with you as its subject heading. I think this is after you had given them the short, I think your clerk, John Grimmer, put it as a 20-minute freebie.
I can't remember the 20-minute freebie, to be frank with you, but the email I seem to recall was dated the 18th of July, so this is a few days afterwards.
In short, Brian looks like the right man for the job. In my view, he was very impressive. He's clearly taken this type of exercise before and is very live to the political dimension. Again, were you made aware that your client believed that there was a political dimension to the issues that the Post Office was facing?
Well, if that line in this email is accurate, then clearly I must have been. But what it was, particularly at that time, I can't tell you.
Was this political dimension described to you?
Well, as I say, Mr. Beer, I can't remember. If the email is accurate, maybe something was said about it, but I can't remember what that was.
They seem to think that you were very alive to it, the political dimension.
Well, everybody probably at that time who read anything about Post Office was probably alive to the political dimension. I don't think I had any unique insight into it.
What would you understand the political dimension to have been in mid-2013?
Well, again, speculating, because I can't remember this. It would inevitably be the fact that Post Office was, in effect, a government-owned organisation. And clearly the balloon was going up in respect of what had happened during the course of past convictions.
Mr. Parsons carries on. Big question. Is Brian's work private advice for the Post Office or an independent assessment of the Post Office's criminal law position, one for us to think about? Do you understand the distinction between those two species of instruction?
Absolutely.
Of those two, well, firstly, could you explain what you understand the distinction to be?
Well, private advice is advisory work to the client, which is privileged, and an independent assessment of Post Office's criminal law position, with the emphasis on the word independent, would be something that might be published.
How was the instruction first presented to you on those two alternatives?
Mr. Beer, like me, you will know that the terms of reference went through so many drafts, and frankly, when I saw them, for the purposes of making my statements, I couldn't sort out one from the other with any great ease. But I have to say, at no time did I ever understand that this was going to be some publishable independent review. And I think, unless you correct me, that all of the terms of reference, in fact all of the drafts, were always couched in terms of non-publishability. And that was always my understanding. And you'll note what I said in my witness statement, that when I did come to write the general review, it was headed legally, professionally privileged. I set out all the terms of reference, which included its non-publishable nature, and also that it was clear to me that this was advisory in nature and not an independent investigation.
So of those two species of instruction set out there, you understood this to be client advice in the ordinary sense?
Yeah, private.
And you were not being asked to conduct a public or independent review of the Post Office's prosecutorial investigatory practices or its past prosecutions?
No, sir.
If the latter had been the case, that you were instructed to conduct an independent assessment of the Post Office's criminal law position as it's put out there, how would you have approached your task differently?
I might have asked for more assistance than I had. So I might certainly have suggested that it would have to be far more wide-ranging and searching if it was in the nature of a proper investigation rather than advisory. And so I would have almost certainly said I wanted resources. Terms of reference might have been different because in the nature of even a non-statutory inquiry or an investigation, you want to think about procedural fairness to people who might be criticised in the course of a publishable document. So all of those things I would have thought about, and I think my approach to it would have been very different.
So your instructions, your terms of reference would have been different, your approach would have been different, the resources that you would have asked for would have been different, and presumably your relationship with your client would have been different.
Yes, I mean the whole thing, the whole approach would have been entirely different. I would have kept them at arm's length, and I think it would have taken a substantial period of time, longer than it actually did, although the general review took, as you can imagine, a long time to put together without any assistance. I'm not criticising, but that's the fact. But it would have taken much longer to perform a proper independent investigation, of which, since that time, I have experience.
Later in the piece, the inquiry is aware that the Post Office came to rely on the work that you did do as having given the reviews conducted by Cartwright King great or greater credibility.
Yeah.
Were you aware when you were instructed that that might occur or was to occur?
Forgive me for asking, do you mean within the organisation or outside the organisation?
Outside the organisation. To, for example, the CCRC. Essentially, and I'm summarising greatly here, you can trust the reliability and integrity of what we've done in reviewing our past convictions. After all, we've got First Senior Treasury Counsel reviewing the work of Cartwright King.
Well, I think I was aware that the Post Office was either likely to do that or had to it. I know I was privy, I think, to some of the correspondence that went to the CCRC. But yes, I suppose I was alive to that possibility.
And so in that sense, the Post Office was treating your work as falling between two stools. It was private work, enjoying privileged, but the existence of which was relied on for benefits when deployed outside the organisation?
Yeah, I suppose you could say that.
So they kept your advice private, but used your name to, would you agree, bolster the integrity of what they were doing?
That's a possible inference.
After receiving these instructions to, this can come down, sorry, after receiving these instructions to advise the post office, were you advising as a prosecutor briefed by a prosecuting authority, or as a member of the independent bar with considerable prosecution experience advising a commercial entity?
Principally the latter, but not forgetting the former.
And why do you say it was principally the latter, advising a commercial entity
Because
that happened to prosecute people?
Yeah, well, because Post Office is or was a private prosecutor. But at the same time, because of my history and my experience, you have to always have in mind that even a private prosecutor has to act as a minister of justice and act with fairness. And I made that clear, I hope, pretty early on. And so I always had in mind all of the principles which I was very much alive to in advising them.
In that calculus, did you bring into account the fact that although the post office was a commercial entity, it could be seen as a public authority in that it was government owned?
I think I was actually asked that question, and I'm struggling right now to remember where it is I confronted that issue. But I did. But at the same time, I don't think it made any real difference to my approach to the questions I was asked to answer.
And why was that?
Because at the end of the day, whether you're a private prosecutor or a public authority which prosecutes, the principles are the same.
Did you consider whether you were approaching the matter from the perspective of being the subject to the same ethical standards as if you had been asked to advise, say, the CPS?
Yeah, my ethics would never have changed.
This issue, the capacity in which you were advising, doesn't appear to be touched on in any of the advices, i.e. I'm advising you as a commercial entity, but the same applicable ethical standards apply. Was there a reason for that?
I can't say if there was a reason. I probably didn't even think it was necessary to have to spell out the precise capacity in which I was acting. But as I have said, I can remember very early on advising the post office of what its duties were, and it had to act with fairness.
Was there any shift in the basis on which you were instructed when you were instructed on behalf of the post office in the Court of Appeal, essentially to prosecute?
Any shift?
Yes, any difference?
None that I can think of, no.
Were you ever contacted by, or did you ever contact BTO, a firm of solicitors in Scotland, instructed to advise the post office in Scotland?
Not once.
Do you know whether your draft or final versions of your advices that were addressed to the post office were distributed to BTO solicitors in Scotland or to the Crown Office and Procurator Fiscal in Scotland?
I have absolutely no idea about that.
Was there any communication with you about the distribution north of the border of the advice that you were giving?
None that I recall.
Thank you. Can I turn to the second topic then, please? This is Mr. Clark, Simon Clark's advice of the 15th of July 2013 and the treatment of Gareth Jenkins. Now, I think you, as you've said already, you were asked for your views and observations on the terms of reference for your initial instruction, correct?
Yes.
And so you were asked to advise on what you should be asked to advise on.
Yep.
I've got that right, yes?
Yes.
Okay. Can we look, please, at poll 406804? And if we go to the final page, which is page 5, please, and scroll down a little, we'll see that this is your document, and it's signed off on the 2nd of August 2013. And so if we go back to the first page, please. So these are essentially your observations on the draft terms of reference, your instructions.
Yes.
Do you know why they weren't just called instructions if this was a straightforward client-barrister relationship giving private advice?
I suspect because they came from Bond Dickinson and the nature of that firm. They weren't a criminal firm, and I'm not even sure that Gavin Matthews, who was the principal point of contact, was a litigation lawyer.
Even in civil law, though, when barristers are instructed, they're normally called instructions.
You may be right, but I have to say I didn't see any substantive difference between the use of the terms of reference or instructions.
In any event, this is your advice on the things that you're asked to advise on. And if we look, please, at page 3, under the heading Process, you say paragraph 2 of the process section of the overarching terms of reference includes the possibility of my meeting Dr. Jenkins. I note this is queried. Not meeting and hearing him, where there may be questions potentially impacting on non-disclosure by him and his role as an expert, risks exposing the final report to criticism. However, this is not a judicial or public inquiry with the formal receipt of evidence. This is something I shall need to think about carefully. At this very early stage, I'm not unnaturally undecided. For now, it may be better for the terms of reference to remain silent about him.
I think I say something more over the page as well about that.
Yeah. At all events, if we just go over the page, paragraph 3, as generally worded, covers it, as is acknowledged in para 2.3 of the covering email, and in my view, should be the wording adopted for both the overarching and abbreviated terms of reference documents. In your witness statement, you say, and no need to turn it up, it's paragraph 21 on page 8, it's clear from this, and that's this document, that early on in my instruction, I did consider whether to meet Gareth Jenkins. I do not have a copy of the document I'm referring to here, which must be an earlier iteration of the draft terms of reference, and I do not know now what was queried, how it was queried, or by whom. In the event, I did not meet Gareth Jenkins, and I cannot find any record I had any further discussions about it, or any record of my reasoning for not doing so. If we go back a page, please, and scroll down. In that final paragraph on the page there, why were you concerned that not meeting or hearing from Mr. Jenkins would risk exposing your final report to criticism?
Well, I think it's in the first line where there may be questions potentially impacting on non-disclosure by him. And so I suspect I had in mind at that point the question, why was it that Gareth Jenkins, particularly in the SEMA Misra case where he gave live evidence, had not disclosed what he knew about those 2 Horizon Online bugs. And so I suspect my thoughts at that time were targeted at that particular issue.
So I'm so sorry.
No, it's all right. But I suspect as time went on, I came to the conclusion that the reasons why he had not revealed those bugs in trials in which he had provided witness statements, or in SEMA Misra's case in particular, where he'd given live evidence, was not ultimately material to the questions I was being asked to consider. It was the impact of that non-revelation on convictions that was what I was being asked to look at.
And Mr. Altman, I'm going to explore that distinction that you've just drawn.
Yeah.
That reasons irrelevant, impact important. Would it be, as you've written it here, that not meeting him would be turning a blind eye to a potentially useful source of information? That's why you wouldn't want to do it.
That's why I would or would not want to do it.
Would not want to do it.
If you're suggesting that I'm turning a blind eye, I was not turning any blind eye to anything.
You'd identified here that if you didn't meet him or didn't hear from him, it would expose your final report to criticism. In the event you didn't meet with Mr. Jenkins, did you?
No, I didn't.
But whilst we're on this point, why was the product of your instructions, your terms of reference, to be called a final report, rather than what we normally provide, which is advices and opinions?
It was just a use of words. I
Well,
think I regard this as an advice. And in fact, the review document is referred to as a review, not a report.
You say it's not a judicial or public inquiry with the formal receipt of evidence, the thing that you were undertaking. Does that suggest that you thought that it was some form of inquiry, a private inquiry or a private review, rather than just client advice?
I think there is a mixing of terms here, but I have no doubt that I was being asked to give private advice to the post office.
In the last line, you say, for now it may be better for the terms of reference to remain silent about Mr. Jenkins. Why did you consider it best for the terms of reference to remain silent on Mr. Jenkins?
Because I hadn't resolved at that point whether I was going to see him.
That's a separate issue, isn't it? Whether or not you saw him, to whether or not the terms of reference should mention him.
Yeah, well, I think I see what you're driving at, but I just felt that we were debating, me and Gavin Matthews, as to what the terms of reference should be. So my view was, if I had not yet resolved to see him, then there was no point sticking it in the terms of reference, which were ultimately my instructions.
Had the centrality of Mr. Jenkins to the issues been communicated to you by this stage, August 2013?
Well, I'd clearly understood what had happened in the trials, and I'd clearly read the Clark advice.
And so it had either been communicated to you, or you had by this time realised that he was a central figure.
I understood that.
Why wasn't there an investigation into how and why Mr. Jenkins came to give evidence that Mr. Clark had advised was misleading and a breach of his duties to the court?
Well, when you say an investigation, because I wasn't conducting an investigation, I was giving advice to the post office.
Why didn't you give advice that the post office should investigate why Mr. Jenkins had come to give evidence that was, according to Mr. Clark, misleading and in breach of his duties to the court?
Because I come back to what I had thought, that the advice I was giving was about the impact of that failure on the prosecutions and the convictions, not the reasons why he had failed to do it.
What did you know at this point about how Mr. Jenkins had been instructed?
Do you mean his instruction as an expert?
Yes.
I'm not sure I was told.
Did you ever ask for or review any instructions that he was given?
I can't remember having done so.
Did you ever appreciate the risk that Mr. Jenkins had himself been manipulated by the post office or misinstructed?
No. I suspect, I assumed, because I was not told otherwise, that he'd been properly instructed throughout.
Did you check whether that was in fact the case?
There is nothing in the material I've seen to say that I did.
Did you check whether Cartwright King were going to address that issue, namely the proper instruction of Mr. Jenkins as an expert?
Address it with?
By examining the files or by speaking to Mr. Jenkins?
I can't remember if that was said or not.
As part of your assessment that we're going to come to in the general review, later on, you say that Cartwright-King's review was fundamentally sound.
The process, I felt, yes.
This issue, by removing him from the terms of reference, meant that the Gareth Jenkins issue remained shelved, didn't it? Never to be returned to.
Not during my review, no.
Did you ever get the sense that nobody in the Post Office, or indeed Cartwright-King, wanted to look too deeply at how Gareth Jenkins had been instructed, and instead their better narrative was that he personally was to blame for disclosure failings?
I never thought that, and I never saw it, and doing the best I can, I don't think I ever heard it either.
Now, the document that you said in your witness statement that you hadn't got, the draft terms of reference upon which you were commenting, can we look at those, please? I think they are POL 00298010. These are dated the 26th of July 2013 and are prepared by Bond Dickinson, as we can see in the top right. And so these are the draft terms of reference. And if we just pan out a little bit, please. You can see they're divided into instructions, process, output, and then over the pages, timing. And just on instructions,
well, pausing there, Mr. Beard, you made the point before that the word instructions wasn't used. It is.
Under the heading of terms of reference?
Yeah. But the fact is the word instructions is to be found there.
One, to review and advise the Post Office in a written report on its strategy and process for reviewing past and current criminal prosecutions given the findings of the Second Sight interim report dated the 8th of July 2013. Secondly, to advise the Post Office on its response to the CCRC and any subsequent action required in dealing or responding to any actual potential appeals. 3, to advise the Post Office, where not covered by one above, on the role of Dr. Gareth Jenkins and the impact on possible appeals. And so Bond Dickinson had included, as we see, instructions to advise on the role of Gareth Jenkins and the impact on possible appeals, yes?
Yep.
And then under process, if we scroll down a little bit, under 2, to meet with John L. Singh and Cartwright-King, and then in brackets, Dr. Jenkins, to understand the past and current procedure for prosecutions.
Sorry, Mr. Beard, I heard you name John L. Singh. Where do I find that?
Under 2.
Under output or under... Oh, sorry.
Under process, yeah. To meet with John L. Singh and Cartwright-King and query Dr. Jenkins.
Well, that was the query I must have had in mind.
So your draft terms of reference did include, as one of the 5 things that you were asked to do, explicitly to advise on the role of Gareth Jenkins and its impact on possible appeals. Yes? Why did you consider it wasn't appropriate to advise the Post Office on the role of Gareth Jenkins? Why did you, if we scroll up please, suggest that paragraph 3 was removed?
Forgive me, paragraph 3 under instructions.
Yes.
Well, I haven't seen this and I didn't recall advising that it was that paragraph that came out, because I did advise on Gareth Jenkins, the role and the impact on possible appeals.
But you said, we've seen your advice, that these terms of reference should remain silent on Gareth Jenkins. So why should Gareth Jenkins be excised from the terms of reference? Why should he be cut out?
Well, I mean, he wasn't cut out because I did advise about his impact, and I think I come back to the answer I gave earlier, that I felt the the reasons why he had failed as an expert to discharge his duties of disclosure was not what I was being asked to advise upon. It was the impact.
But you were given the opportunity to self-define what you were being asked to advise on.
You're right, I was, and that's the only answer I can give you. That must have been my thought process.
But why at this very early stage were you putting out of reach the possibility of an exploration of Mr. Jenkins' role?
I think my answer has to be the same. I was looking at the impact I felt. By the time I got to agreeing the final terms of reference, that was what was in my mind. I didn't feel, I suppose, partly speculating, it was because I did not feel I was an investigator at this stage. It was simply gathering information and writing an advice on the impact.
Weren't you not loading the dice by excising him in this way?
I don't see it that way.
Now, if we look at the final version of the terms of reference, the one that was settled after your advice, poll 304 0044. These are the settled terms of reference for your appointment. And if we just look, if we scroll down gently, thank you. We can see that Mr. Jenkins' role, and indeed any reference to him, has been entirely cut out from these terms of reference, hasn't it?
Yes.
Can I turn to what you say in your witness statement about this? If we turn it up, please.
What paragraph is it?
It's paragraph 26.5 on page 30. And in the third line, you say why Mr. Jenkins had failed to reveal in his witness statements or evidence the bugs or defects he knew about was not a matter for my review. Yes? That's because you cut it out.
Absolutely.
You're explaining in this paragraph a later aspect of your instructions, and you're explaining to us why your reviews didn't address the issue of why Mr. Jenkins had failed to reveal in his witness statements or evidence the bugs or defects that he knew about. And you say it's not a matter for my review. But again, that's because it was your choice to exclude it, wasn't it?
It was excluded. I don't know what discussions I had with Gavin Matthews. I don't know what my thought processes were between the July version of the draft and the final September version of the terms of reference, other than what I said in the observations document.
Doesn't the approach that you took rather ignore the point that the reason for Mr. Jenkins' failures might well be relevant to whether or in which cases they were disclosable?
I'm not sure that's right, actually, Mr. Beer.
And explain why.
Because what he said about individual cases, I don't think would necessarily make a difference if he had not understood his duties as an expert, and as Simon Clark pointed out, was by and large making the same statements in every case. Then generically, I think his failures fell for disclosure. I don't think asking him about every single case in which he made a statement and the whys and wherefores would necessarily impact, as perhaps you think it would, on disclosure.
If the failures arose from a failure by the post office to A, provide Mr. Jenkins with a proper letter of instruction, B, instruct Mr. Jenkins as to his relevant duties as an expert witness, those failures would be disclosable too, over and above the mere fact of his own failure to disclose knowledge of bugs, errors and defects, wouldn't they?
I agree with that, but they are generic issues of disclosure, not case-specific.
And therefore require to be investigated, don't they?
Well, if that was right, and obviously I didn't know that, but if that was right, they would be disclosable, but I don't think they need to be investigated.
How would you discover whether that was the fact?
Well, if somebody had told me.
But you cut it out, haven't you? You've
Yeah,
excised it.
I know, but it's slightly circular, because if somebody had told me he'd never been properly instructed, I might have taken a different view.
Can we move on, please, to your generic review, please? Poll 406803. This is your general review dated the 15th of October 2013, and this is the main product of your terms of reference, as they've been called, yes?
Yep.
I.e. the terms of reference we've just looked at.
Yes.
And can we look at a part of it, please, on page 47? And paragraph 148. So I should have introduced this a bit more broadly to you. If we go back to page 44.
Page 44.
Yes. Under the heading Gareth Jenkins and his impact on possible appeals. It's within that section. If we go forwards, please, to paragraph 148 on page 47. You say, I'm not clear whether Mr. Jenkins was challenged about the non-disclosure to the post office. That's the non-disclosure of a bug. And if so, what is the explanation for it? But given the second site inquiry, based in part on his relations, has led to the current review, Gareth Jenkins is to that extent tainted, and his future role as an expert is untenable. It should be remembered that the post office had been unaware of the existence of the second of the two defects revealed to second site by Mr. Jenkins until a year after its first occurrence. Before writing this, did you inquire as to the reason for Mr. Jenkins' non-disclosure?
You can read that first sentence in one of two ways. I either did and wasn't clear about it, or I didn't and I wasn't clear about it.
Did you see any post office instructions to Mr. Jenkins in his role as a witness giving expert evidence in prosecutions, or correspondence involving the post office legal department or post office external lawyers regarding Mr. Jenkins giving evidence in legal proceedings?
Again, as I sit here now, I've got no recollection of that.
If you didn't see such instructions to Mr. Jenkins, and I've no material to suggest that you did, why did you not ask to see them to inform your work?
You know, with the clarity of hindsight, Mr. Beer, we can all do things better, and that's something that I could have done better, but I didn't.
You were working, I think, on the basis that Mr. Jenkins knew about the receipts and payments mismatch bug, and that he had first revealed it to Second Sight in the course of their investigations in 2013. Yes?
Yep.
You did not discover, and you were not told, that he'd in fact disclosed the existence of the receipts and payments mismatch bug to the Post Office IT team and an operational team in late September 2010.
You're talking about the issues notes?
Yes.
I didn't know that.
You didn't know that he had written the report, the lost discrepancies document of the 29th of September, and that had been sent to a post office investigator, Alan Simpson, and indeed sent on to lawyers, Rob Wilson, Juliet McFarlane and Jarnell Singh. You didn't know about that at the time you were writing?
No, not only that, but I seem to recall that when the second site report dealt with the receipts and payments mismatch bug, it reported that Post Office didn't know about it until 2011.
Yes.
Yeah. No, I didn't know about it.
You
obviously since, but I didn't know it at this time.
all of that would have put an entirely different complexion on the advice that you were giving, wouldn't it?
I accept that.
And just explain why you accept that it would have put an entirely different complexion on matters.
Well, because if I had known about the issues notes and the other document, the correcting accounting for discrepancies document, all of which came into being, as you say, very shortly before Mrs. Misra was tried in October 2010, I suspect I would have taken the same view as we took much later during the criminal appeals, that that is something that should have been considered for disclosure and disclosed to Mrs. Misra before her trial.
Did you give any consideration to the procedure by which the expert witness, Mr. Jenkins, had been instructed?
Well, as I've said, Mr. Beer, nobody indicated to me he'd never been properly instructed. Looking back, of course, it's something I should have queried, but I rather blindly, I suspect, assumed that that must have been the case.
And so I think you agree that it would have been responsible to recommend to the Post Office that the issue of how evidence from Mr. Jenkins had been obtained was looked into.
It would have been responsible for the Post Office and those instructing me to let me know. I think it would have been, in my case, better to have asked, yes.
On this topic, were you aware that the Post Office did not escalate Mr. Clark's advice, the 15th of July 2013 advice, about Gareth Jenkins
Escalated
to Fujitsu?
I wasn't aware of what was going on in the background.
So you didn't know one way or the other?
I don't think I did.
Thank you. That can come down. I think it follows that you weren't informed at the time that you were advising the Post Office that it was known to the Post Office that Mr. Jenkins either hadn't been properly instructed or may not have been properly instructed as to the duties owed by a person giving expert evidence to a criminal court.
Yes, I should have known that.
Or at least that there was a very serious question as to this.
Yes.
We've got some manuscript notes of a discussion held between lawyers in September 2013 about that issue, whether Mr. Jenkins had been properly instructed and that it appeared that he may not have been properly instructed. That discussion between lawyers, it was Roderick Williams and Martin Smith, that was not revealed to you.
Did you say September?
Yes, 2nd of September.
No.
Do you agree that you ought to have been informed of this, a realisation amongst some of the lawyers that Mr. Jenkins had not been properly instructed, or that there was a serious question as to whether he had?
Yes.
And is that because the issue went to whether it might be indicative of broader failings on the part of Post Office prosecutors?
It would certainly have gone to that issue, yes.
It might be relevant to the scope of disclosure that needed to be given.
Yes. And also, I suppose it's easy for me to say now, it may have changed my view about what to do about the Jenkins problem.
What do you mean it might have changed your view?
Well, I might have come back and said, well, perhaps now I ought to speak to him and find out what was really going on.
Or call for any papers that go to the issue of the instruction of Gareth Jenkins?
Or the absence of them, a surge. I don't know, but that's what probably would have happened.
But it might have gone to the issue of whether there were broader failings on the part of Cartwright King.
Yes.
And whether there was a conflict, accordingly, in Cartwright King advising on its own cases.
Yeah, it's an interesting take on it, Mr. Beer, but yes, I suppose that's right.
Well, it's not only interesting, it would be a matter that would concern you, wouldn't it? If this train of inquiry had been pursued, if this thread had been pulled, i.e. who has instructed Gareth Jenkins and how, that may have been revelatory of disclosure failings, but also of misconduct by prosecutors, mightn't it?
Potentially.
It goes to the issue of how deep into the organisation and how close to the lawyers the problem is, doesn't it?
I agree.
I think you're now aware that not only was Mr. Jenkins not instructed as to his expert duties, but the inquiry has seen evidence in a series of communications that prosecutors actually misstated the nature of an expert's duties.
I'm not sure I am aware of that. Well, certainly I'm aware of the former. I'm not sure I'm aware of the latter.
For example, he was asked, he sent an email to a lawyer saying, what do I expect when I give evidence? And he was told, like any other witness, you've just got to tell the truth in relation to questions asked of you.
Well, forgive me if I've missed it, because I sent an awful lot of documents over the past 7 days, but I'm aware now, but I'm not sure I was aware of that.
And he was told, you can only be asked questions about issues that you've addressed in your report. You can't be asked questions about things that aren't addressed in your report.
I didn't know that.
But the Post Office never volunteered to you that it hadn't instructed Mr. Jenkins as to his expert duties.
No.
And did it provide any email communications which Mr. Singh had with Mr. Jenkins?
Sorry, ask that again, Mr.
Yes. Did the Post Office provide you with email communications between Mr. Jenkins and Mr. Singh, in particular in the course of the SEMA Misra trial?
You mean after my instruction in 2013?
Yes.
I can't remember.
Were you told about the process by which the so-called generic statement written by Mr. Jenkins came to be created?
No.
Is it the case that you became aware that there were serious issues as to the use made by the Post Office of Mr. Jenkins and their instruction of him in the course of the criminal appeals?
I learned a lot then, which I was unaware of previously.
And so I think it follows that no one informed you at the time of your 2013 advices that Mr. Singh, Julia McFarlane, another lawyer in Post Office Legal, and Rob Wilson were provided with the 2 detailed notes about the receipts and payments mismatch bug.
No.
And that whether by inaction or by a positive decision, those documents were not disclosed into SEMA Misra's trial.
Well, obviously I didn't prosecute Mrs. Misra. There is any number of reasons why that might have happened, but it didn't happen.
Were you told at the time of advising in 2013 that people that were called senior stakeholders within the Post Office had been informed of the receipts and payments mismatch bug in November 2010 and had been informed by a note about the receipts and payments mismatch bug?
Who do you mean by senior stakeholders?
Well, if we look at the document, poll 0029 4684. So you'll see this is an email of the 15th of November 2010.
Yeah.
The subject is a receipts and payments resolution proposal meeting. I think it's an invitation. you'll see there's a list of required attendees and optional attendees, and a note is attached. And then if we scroll down, please. Thank you. The aim of the meeting is to discuss the working group proposal to resolve discrepancies generated by branches following a specific process during completion of the trading statement. And then if you just scan the next few paragraphs.
Do you want me to read those, Mr.
Yes, please.
Yeah.
And then if we go over the page, please. So just look at the foot of the previous page. There are several solutions to resolve the issue at the affected branches. They are as follows. And then if we scroll down. Solution 1, 2, 3. You probably recognise those.
I do, yeah.
Because they're from the notes
Yeah.
of late September, early October 2010,
Yes.
where there was a discussion over which of these three solutions to adopt. And I think you recognised subsequently that solution 1 was a very significant one, not only for the receipts and payments mismatch bug, but because it revealed that Fujitsu had the ability manually to write entry values into the local branch account without the sub-postmaster knowing. Is that right?
I think so, yeah.
So it seems on the 15th of November 2010 that this is still an open discussion about which solution to adopt. And then if we scroll down, please. At the foot of the page, it says, "We are looking for you as senior stakeholders to agree this approach is a way forwards." So the point I'm making is that there had been some non-disclosure in SEMA Misra's case before trial, and then afterwards there was still a discussion going on in November 2010 within senior stakeholders of the Post Office as to the receipts and payments mismatch bug.
Yeah.
This is all. This would all be news to you, advising in 2013, because you were under the impression that the receipts and payments mismatch bug had been discovered by Second Sight.
Second Sight on the information of Gareth Jenkins.
Yes. And so you didn't know, when you were advising, how high up in the Post Office knowledge of the receipts and payments mismatch bug had gone?
I knew none of this at that time.
Can we look at the time, closer to the time that you were advising them, please? Poll 0002 9618. And if we scroll down, please, and keep going, and keep going. Thank you. An email of the 25th of June from Mr. Warmington of Second Sight to Simon Baker within the Post Office, giving an extract from the draft Second Sight report. This is the draft section of the report dealing with the two defects. Please let me know if I've got anything wrong.
Sorry, I'm just trying to pick up where you found that.
Yeah. So where it says, Simon, this is the draft section of the report dealing with the two
Please
defects.
let me know, yes, sorry.
Please let me know if I've got anything wrong. Yes?
Yep.
And so he is sending a draft section of the Second Sight report that deals with the two bugs, yes? And then if we scroll up, please. A reply from Mr. Baker, I'll need to double check a few things. And then keep going up, please. stop there. Mr. Baker, seemingly to Leslie Sewell, says, Joss got this from wrong. I can get back to him on most of the questions, but need your help on who in Post Office knew about it. I know from the email that Rod sent that Mike Young knew, but don't know if it went any higher. So within Post Office, a discussion of how high up within the organisation knowledge of the receipts and payments mismatch bug went. And then scroll up, please. Leslie Sewell, the Chief Information Officer, replies, copying in the company secretary, I don't know if it went any higher than Mike. Andy Mook also managed service at the time. And if I remember correctly, Mark Burley was also involved. Can't recall whether we said anything to the press. And we didn't have an independent board. Paula Venables would have been network director. So there was an internal discussion approximately to the time that you were being instructed as to how high up within the organisation knowledge of the receipts and payments mismatch bug went, yes?
Yeah. I mean, I never saw any of this.
No, I'm about to say.
No.
The fact of the knowledge of the receipts and payments mismatch bug by senior stakeholders was not revealed to you.
No.
The fact that lawyers responsible for prosecuting knew about the receipts and payments mismatch bug was not revealed to you.
No.
And the fact that proximately to the time that you were being instructed, the Post Office was having an internal debate about how high up within the organisation knowledge of the receipts and payments mismatch bug went was not revealed to you.
No.
When were you first made aware of the mismatch bug?
In the the RPM, the receipts and payments mismatch bug, you mean?
Yes.
When I read the second site interim report. The 8th of July one.
And when did you first see an RPM, as you call it, document referring to the three options?
I first actually saw the reference to those three solutions, if my memory serves me, in Mr. Justice Fraser's judgment on the Horizon Issues trial.
So after December 2019?
Yeah.
Or in or after December 2019?
Yeah. Although, not to be unfair to Post Office, one of the documents I was asked to look at, one of the additional documents, which I hadn't seen before, was an index to the bundle of the material which Roderick Williams sent to me for the purposes of the 2016 review. And under the second section, in relation to balancing transactions, was reference to the issues notes and the correcting discrepancies document. But I don't think I ever opened up that part of the bundle, because you'll recall Roderick Williams and I agreed in 2016 that I wouldn't be advising on the balancing transactions issues because they were instructing Deloitte to finalise a report. So, not to be unfair to Post Office, it was there, but I don't think I ever saw it or read it in 2016. And frankly, if I did, whether I would have appreciated its impact, I'm not sure.
We saw that under Solution 1,
Yeah.
as well as obviously revealing the fact of the RPM bug, it also gave an insight into the facility for a form of remote access.
Yeah, can we go back to it, do you think?
Yes, I think so. Poll 0029 4684. Page 2. Solution 1.
Yes, thank you.
What were the implications for you that a form of remote access, meaning that branch accounts could be changed without branch knowledge, either in error or by a malicious actor, meant to the prosecution of offences?
Well, as I say, I didn't actually see, in the sense of read the documents until we came to the criminal appeals, but it would have raised the possibility of unexplained shortfalls not being unexplained.
Was there anything, would it have revealed anything broader than that about the ability of a prosecutor to stand before a court?
I wouldn't say this is a real loss.
Yes.
Well, of course it would impact on that.
So I missed your answer.
Forgive me, of course it would impact on that.
And how would it impact, and in what way?
Well, it would impact on any prosecution of the offence of theft. If you are trying to prove that there has been the permanent of the appropriation of money with the requisite intention, you would struggle if that was known. And sitting here thinking about it, it would probably also impact on potential allegations of false accounting as well.
And in what way in relation to false accounting?
Well, in the situation where a postmaster would offer the prosecution a plea to false accounting in consideration of the post office dropping theft, if a postmaster had known that this kind of activity had interfered with the branch accounts, then they might be pleading guilty on an entirely false basis, that any false accounting for which they felt they were responsible for or had almost certainly been responsible for might not be the case.
Thank you. So that's an appropriate moment to take a break, if it's convenient to you, until 11:15.
Yeah, certainly.
Thank you very much, sir. Good morning, sir. Can you still see and hear us?
Yes, I can. Thank you.
Thank you, Mr. Altman. Having looked at what was cut out from your review in relation to Gareth Jenkins and what information was not revealed to you by the Post Office, can we look at what you did do on your more limited understanding or knowledge of the position in relation to Mr. Jenkins? Can we see, firstly, your general advice, please, your general review, poll 406803. Remembering this is your general review of the 15th of October 2013. And can we look at page 6, please?
Excuse me. Yeah.
And scroll down to paragraph 10, Roman 10. And this is essentially an executive summary
Yeah.
of the review. And in relation to Mr. Jenkins, you say, I agree that Gareth Jenkins is tainted and his position as an expert witness is untenable. Thus, a new expert should be identified as soon as is practicable. Yes?
Yeah.
Were you basing that view principally upon what you had read in Simon Clarke's advice of the 15th of July 2013?
Yes, I think that must be the case.
What was done to inform past defendants and those in ongoing cases that Mr. Jenkins had wrongly withheld knowledge about bugs in the Horizon system?
I know what you're driving at, Mr. Beer, and it's something in recent weeks which I have thought about, and it's something that should have been disclosed to appropriate people.
Is the answer then that nothing was done to inform convicted defendants or those in any ongoing cases that Mr. Jenkins had wrongly withheld his own knowledge of bugs in the Horizon system?
Yeah, I think unhappily that has to be the case. I mean, with the benefit of hindsight and having thought an awful lot about this, it's something that should have been considered for disclosure and disclosed in appropriate cases. No question.
And should have been considered for disclosure by you, Mr.
Yeah, I'm accepting that. Yeah.
Thank you. Can we look at Mr. Clarke's advice on Gareth Jenkins to see what he said? That's poll 406798. This is the advice of the 15th of July. We can see that from the last page, page 14. We just scroll down. So the Clarke advice of the 15th of July about Gareth Jenkins. And you'd certainly got this, I think other material shows, by at least the 2nd of August.
Yes.
2013, so within a couple of weeks of it having been written. And then if we just look at what Mr. Clarke had said by looking at page 5, at paragraph 15, he says, Gareth Jenkins has provided many expert statements in support of the Post Office and Royal Mail Group prosecutions. He's negotiated with and arrived at joint conclusions and joint reports with defence experts, and there's a cross-reference to Khayyam Ishaq's case there, footnote 7, and he's attended court so as to give evidence on oath in criminal trials. And then if we go forwards, please, to paragraph 37 on page 13. What does all this mean? It means that Gareth Jenkins has not complied with his duties to the court, the prosecution or the defence. The reasons why the 38 Gareth Jenkins failed to comply with this duty are beyond the scope of the review. The effects must be considered. I advise the following to be the position. Gareth Jenkins failed to disclose material known to him but which undermines his expert opinion. This failure is in plain breach of his duty as an expert witness. His credibility as an expert witness is fatally undermined. He shouldn't be asked to provide expert evidence in any prosecutions. Those current and ongoing cases where Gareth Jenkins has provided an expert witness statement, he should not be called upon to give that evidence. We should seek a different independent expert to fulfil that role. You agreed with those views, didn't you?
Yes.
Was the agreed position then that you and Mr. Clark had arrived at that Mr. Jenkins hadn't complied with his duties to the court, to the prosecution or the defence, that he was in plain breach of his duty as an expert witness, that his credibility as an expert was fatally undermined, to your knowledge, ever disclosed to past or current defendants?
At that time, no.
And just to be clear, we're not here referring to the fact of his knowledge of the bugs, errors and defects said to have been concealed by him, but rather an assessment by the prosecutor that his credibility had been fatally undermined. They're two different facets, do you agree?
They are, and I accept, as I've said already, that to my knowledge that was not disclosed.
Was there ever an investigation into whether others involved in the prosecution of sub-postmasters knew about bugs but had not disclosed them?
I'm just struggling to think about who you might mean, others
Well,
involved in
John L.
prosecution.
Singh, Mandy Talbot, Rob Wilson, a whole group of investigators who had knowledge of bugs.
Mandy Talbot, I'm not sure that's a name familiar with me. John L. Singh obviously is. And Rob Wilson, I never met, but I know the name. And forgive me, the question is whether it became obvious to me.
No, what was there, to your knowledge, ever an investigation into how wide the knowledge of bugs, errors and defects pre-prosecution, pre-July 2013, went?
No.
If Mr. Jenkins had withheld from prosecution cases his knowledge of bugs, did you ever advise the instigation of an investigation as to whether such concealment of bugs was known about or facilitated by others?
And being frank on my state of knowledge at the time, and one always has to be careful, and I'm sure you'll accept this, Mr. Beer, that, you know, as I termed it earlier, that the clarity of hindsight provides a clear-sightedness, as it were, that you didn't have at the time. But at that time, I don't think it crossed my mind that it went wider than Gareth Jenkins.
That document can come down, thank you. Was any consideration given by you, or to your knowledge by others, as to whether the agreed position that we've just seen reached between you and Mr. Clark was not privileged?
I don't believe we ever had that discussion.
Do you think there ought to have been a discussion as to whether this meeting of minds between prosecutors was not privileged information and ought to have been revealed?
Well, I've already agreed with you about the latter. And if the latter had been the decision I'd arrived at or the advice I gave, then I don't think privilege would have come into it.
So is it, on your understanding, a failure to think about the issue rather than thought being think, given but privilege cloaking the answer?
I don't think privilege would have, if I had applied my mind to the fact that Gareth Jenkins' credibility was in issue and his assessment as an expert was in issue, I think I would ultimately have advised that that ought to be disclosed in appropriate cases. I clearly didn't. I can't think now why I didn't. I'd like to say it was a misjudgment, but I'm not even sure there was a judgment. I don't know why. I think we were, if I have to think back and speculate, I think the focus was so geared towards these two new bugs that just slipped through, as it were.
The disclosure that was given on your advice to convicted or some convicted defendants was A, the second site report,
Yeah.
and B, the Helen Rose report.
Yeah.
Neither of those documents revealed anything about Gareth Jenkins' state of knowledge of the two bugs, did they?
No, I accept that. They didn't.
That's a further problem, isn't it? Because
Yeah.
you reached a position that Mr. Jenkins was fatally undermined, he breached his duties, the response to which is to disclose two documents, neither of which reveals that information to a defendant.
No, there would have been a gap in anybody's knowledge. I accept that.
There was therefore a well of knowledge sitting below the surface
Yeah.
that was not disclosed. And can you help us, why was that?
I've given the reason. I think the focus was so targeted towards these two new bugs and their impact on affected cases that it's hard to look back and think, how on earth did I miss that? But I think I just missed it. It's as simple as that.
Is it a little worse than that, though? Because if we look at the second site report, i.e. the thing that was disclosed to convicted or some convicted defendants, poll 302 9650, this is the second site report of the 8th of July 2013. If we look at page 5, please. Foot of the page, para 6.4. In the course of our extensive discussions with Post Office over the last 12 months, Post Office has disclosed to Second Sight that in 2011 and 12 it had discovered defects in Horizon Online that had impacted 76 branches. And then it continues with the first defect and the second defect over the page. So the Second Sight report was saying that the disclosure of the bugs came from Post Office.
Which I frankly don't understand.
Not Gareth Jenkins.
No, but which surprised me, because clearly Second Sight, not just Cartwright King, I've read that, and I'm well aware of 6.4. And I didn't understand why Second Sight itself was not reporting it was Gareth Jenkins. I'm not criticising them at all for 1 minute, please don't.
So you knew that it was Gareth Jenkins who was said to have made the relevant disclosure.
Yeah.
And therefore, if the report had included that, it would have been a disclosure of his own knowledge of bugs that he hadn't disclosed at the time.
Yeah. Can I say I didn't realise this at the time? I don't think it registered. Obviously, since I've looked at this again. And I've puzzled about 6.4, why it was Second Sight didn't name him, but they didn't. Because it wasn't Post Office. I don't think it was Post Office anyway.
And so the document that is disclosed to some convicted sub-postmasters materially misleads them on this point.
Yeah, but I wouldn't want you to elide the failure to advise disclosure of the fact that it was Gareth Jenkins who brought this to the attention of Second Sight and the fact that Second Sight itself reported Post Office. I don't think anybody made that link.
Thank you, that can come down.
In fact, I know no one made the link, and I certainly didn't.
What criminal offences may have been committed by Gareth Jenkins based on the facts as you knew them by the time you were advising in October 2013?
I'm not prepared to speculate about that, and I'm not prepared to speculate because if you're thinking about perjury requires certain conditions which nothing I had seen suggested might be present. And perverting the course of justice and having a tendency to pervert the course of justice with the requisite intent is a particular offence, and I was not prepared to speculate, nor am I now, as to whether he was dishonest or just incompetent.
I asked what criminal offences may have been.
Yeah, well, the maybe would include those two, but as I say, it's speculative on my part because I don't know all the evidence.
So at the time, on the basis of the information that you had, the possible offences that may have been committed by Gareth Jenkins included possibly attempting to pervert the course of justice?
Perverting the course of justice.
Right. Conspiring to pervert the course of justice?
Well, that depends on whether there are two or more parties involved.
And possibly perjury?
Possibly.
Do you agree that nowhere in the Clark advice on Mr. Jenkins, in any subsequent advices written by Mr. Clark that you saw, and nowhere in your advices was the question raised as to whether or not Mr. Jenkins had possibly committed criminal offences?
No.
Why was the question of possible perjury or possibly perverting the course of justice never addressed?
Because I think at that early stage, and in fact with all witnesses who give evidence to civil or criminal courts, or indeed in public inquiries, simply because a witness hasn't complied with their duty in this particular case as an expert does not lead inexorably to the conclusion that somebody has committed any of those offences. And again, it would never have crossed my mind that that required a police investigation.
You're ahead of me, Mr. Altman, a little bit, but I'm asking at the moment why we see no consideration of it.
For that reason, it wouldn't have crossed my mind that any police investigation or any consideration of whether he had committed offences was anything A, I was asked to do, or B, I would have volunteered.
Given that the assessment by Mr. Clark was that Mr. Jenkins had known about the bugs in the Horizon system and had failed to reveal them, while simultaneously stating that the Horizon system was robust when he gave evidence in the SEMA Misra case. But why was the question of the commission of a possible criminal offence not discussed by anyone?
Well, I think I've answered that, Mr. Beer.
Was it discussed outside the confines of the advices, i.e. in conference or in telephone conversations?
I have no recollection of that.
Was there any discussion about the provision by Mr. Jenkins of statements which had given false information, i.e. the criminal consequences or possible criminal consequences of that?
I have no recollection of that either.
I'm sorry, Mr. Altman. We've heard a lot at this inquiry of I can't remember or I have no recollection. I am taking what you were saying. Well, let me not say that. How am I to take what you were saying? That you simply have no recollection one way or the other?
Yes.
Or you do? Yeah, that's it. Fine.
Yeah, I'm sorry. I know it's rather loose language, but I'm being asked for recollections of conversations which I've never put in writing from getting on for 11 years ago. So
No. I follow that, but in my experience, some people say I have no recollection of that when they mean I don't know one way or the other.
Yeah.
Others use it when they actually mean I don't recollect anything of that kind, but if there had been, I rather think I would remember, if you see what I mean.
I do. Well, it's the former.
It's the former. Thank you.
Mr. Altman, you said today that you think that your approach at the time would have been, this was just one of those occasions, of which there are many, on which a person gives false or inaccurate evidence to a court or an inquiry. Is that right?
Yes.
Did you instigate or advise the instigation of any inquiries or an investigation into whether that was in fact the case or not, i.e. by post office?
No.
Wasn't that important?
It could have been important, but I don't think I don't think that was my role.
You seem to be saying, Mr. Altman, that the fact that a witness has given false evidence in court is just one of those things.
No, I'm not saying that.
Well, can you help us with exactly how you thought about it then? Because we don't see in any of these papers the suggestion that the conclusion that he had given false evidence be revealed to defendants, that the police be called in, that he might have committed a criminal offence, or that anyone should pursue in any way whatsoever the evidence that he gave. It sounded from your answers earlier that lots of people give evidence that's false in court, meant that you just described it as one of those things. Am I wrong to take that?
No, well, I may well have done. I may well have come to the conclusion that, that I was not prepared to speculate about what he had done and, as I said earlier, why he had done it. But secondly, witnesses can be incompetent and not dishonest. And I was not probably sure at that time that wouldn't be a huge hammer to crack a nut. I just had not been presented, I felt, with sufficient evidence to infer what you seem to be suggesting I should have done.
Nowhere in your general review, would you agree, was any consideration given to the disclosure of the clerk advice about Mr. Jenkins' lack of credibility, your view that Mr. Jenkins was a tainted witness, to the CCRC?
Not at that time, no. But it went to the CCRC, as you know, the general review.
Do you agree that the failure to advise, that the clerk advice and your own opinion, or at least the substance of the conclusions that were reached, ought to have been considered for disclosure?
If we're still talking about Gareth Jenkins' credibility and the assessment of a witness, I've accepted that twice now.
Did you consider the question of making a report to the Attorney General?
No.
Or the DPP?
No.
And I think you said that it didn't cross your mind to advise to call in the police?
No.
Would you agree that as you didn't advise those things, that failure contributed to those facts not emerging until the Court of Appeal Criminal Division?
I'm not sure I am prepared to accept that, because the CCRC had the general review and every word you've quoted at me from it so far in February 2015.
And so are you suggesting that if the CCRC had wanted to disclose that to defendants, applicants or appellants, it was down to them to do so?
They were able to do it subject to their duties under the Act under which they operate. But the fact is they had all of that information, and if they had felt that any part of what I had done had been remiss, or there were gaps in the advice I had given, then it was within the gift of the CCRC to conduct their own investigation.
If Mr. Jenkins, as a mainstay of the Horizon system, one of its architects...
Did you say if?
Yes, if Mr. Jenkins, a mainstay of the Horizon system, had concealed some bugs, did the possibility occur to you that more bugs were in his knowledge?
I think not, because I think he was clearly prepared to reveal to Second Sight in a report which he must have realised would be published. Those two bugs in Horizon Online. And so, no, I wasn't aware, and it didn't occur to me that there were many more, certainly not what came out in the Horizon Issues trial.
At no point in Mr. Clark's advices, nor in, I think, yours, is the question of the relevance of the conclusions which you'd reached about Mr. Jenkins addressed through the prism of a possible abuse of process argument considered. Is that right?
Well, I think in general terms I was talking about non-disclosure.
Yes, and so you didn't view this through the different lens of its effect on an abuse of process argument.
Well, I did later, but these are different sides of the same coin. If non-disclosure itself can often be the argument which underlines the first limb of abuse of process. So it's all much the same argument.
Can we look forward at many, many years to UKGI 301-8137? And this is the Horizon Issues judgment with which you'll be very familiar. And I think you were provided with a copy of this under the embargo provisions at the time that it was still in draft in December 2019 and asked by the Post Office to advise on it, yes? And
I think I was only given certain sections of it.
Oh, I see.
Yeah.
Can we look, please?
I wasn't given the whole thing.
Can we look, please, at page 150? And paragraph 508. The absence of Gareth Jenkins, that's the absence of Gareth Jenkins from the Horizon Issues trial. It's entirely a decision of the parties which witnesses they choose to call in any proceedings. The position of one person, however, who did not appear in the Horizon trial must be considered in more detail than would be usual, as the claimants make considerable complaint about this. The person in question is Gareth Jenkins. And then if we go to page 152, please, paragraph 511, when Post Office served their evidence, sorry, my monitor has
Gone blank.
gone blank.
No.
Has yours as well, Mr. Altman?
Yes.
Okay.
I say amazingly, mine hasn't.
So can we pause for 2 minutes, please? It's okay, because they can't see it. So I'm told that RTS are just rebooting the system. Thank you. We were just looking at paragraph 511. When the Post Office served their evidence of fact, the claimants had asked the Post Office why there was no statement from Mr. Jenkins, whether Mr. Jenkins was available to give evidence, and also whether he was involved in one of a team of what the claimants referred to as the shadow experts. This description was challenged by the Post Office, and the question of shadow experts is addressed further below. No explanation was given for Mr. Jenkins' absence in response to these requests or in evidence in the trial, although it was confirmed that Mr. Jenkins was not one of the team of so-called shadow experts. 512, there the matter might have rested. However, in the Post Office's closing written submissions, an explanation of sorts was for the first time provided. Reading on, this explanation by the Post Office included the following passages in its written submissions. 144, the claimants understandably complain that Mr. Jenkins and the other source of Mr. Godseth's information could have given some of this evidence firsthand. However, 1, taking account of Mr. McLachen's evidence specifically addressed things said or done by Mr. Jenkins in relation to the Misra trial, Post Office was concerned that the Horizon Issues trial could become an investigation of his role in this and other criminal cases. 2, moreover, Post Office was conscious that if it had only adduced first-hand evidence in the trial, it would end up having to call more witnesses than could be accommodated within the trial timetable. And 3, furthermore, so far as Post Office was aware, the relevant parts of Godseth 2 were most likely to be controversial. For example, the Misra trial was a matter of public record, the 4 bugs were covered by contemporaneous documentation, and Post Office had no reason to doubt Fujitsu's account of the documents it held. End quote. Did the fact that the Post Office explained the absence of Mr. Jenkins in this trial as a witness in these terms in any way concern you or surprise you?
I'm not sure which part of the judgment this is and whether these are the parts of the judgment that were sent to me. But what surprises me is, I suppose if that's the question you're asking me, is, and I'm being careful here because this is the commercial litigation, but of which others had conduct, but using him in the background as a shadow expert to inform their case, I suppose, is the key issue.
The reasons 1, 2, and 3 given for not calling him in their closing submissions do not include that Mr. Jenkins had for at least since 2013 been regarded as an unreliable or tainted witness.
Well, I see that here, Mr. Beer. I don't know because I'm just not sufficiently familiar with this judgment, certainly not now, whether that was dealt with anywhere else. But if you're focusing my attention on that particular paragraph, then you're right.
Did you think, when reading this, hold on, there's nothing here about Mr. Jenkins having been assessed by the Post Office to have been a tainted and unreliable witness?
I can't tell you what I thought when I read this.
I take it that you didn't consider it a part of your duty to raise that kind of issue with the Post Office.
Mr. Beer, I can't remember what I thought when I read this paragraph, or assuming I did, back in, what was it, 2019?
Thank you. Can we go back, please, to the breadth of your terms of reference by looking at poll 406801? And again, this is a copy of your interim review dated the 2nd of August 2013, so a stopping off point towards your general review. And if we look at page 5, please, and paragraphs 11, 12 and 13, you say, I wonder whether non-disclosure by Gareth Jenkins of aspects of the Horizon system is the only potential issue that arises in these cases, or whether there may be other issues which need to fall within the remit of your review. I question whether the sole issue of non-disclosure is too restrictive an approach to take to the review. I've considered the list of issues which were reported to Second Sight in the course of their review by multiple sub-postmasters as being of particular concern. One such concern was, quote, post office investigation and audit teams that have asset recovery or prosecution bias and fail to seek the root cause of reported problems. I've also considered spot review SR22, in which, according to the sub-postmaster, the issue was the lack of synchronisation between post office and Camelot records for remmed-in scratch cards. Reading on, this case example does not appear to me necessarily to be an issue of non-disclosure, but one that may be argued to relate solely to the proper functioning of the system. The spot review leaves the reader with the sense that there remains a dispute between the sub-postmaster and post office regarding this case. Has this case and others like it fallen within Cartwright-King's review? And so in those 3 paragraphs, you're saying the review by Cartwright-King is focused on non-disclosure. Reading what Second Sight and some associated documents say, I wonder whether the terms of reference for their review need to be much wider. Agreed?
Yes.
What issues other than non-disclosure did you apprehend or appreciate?
Well, looking at paragraph 12 again, it's almost impossible to put my mind back and, as it were, back engineer what I was thinking about in those paragraphs. But one issue has to be those last 3 lines of paragraph 12. The post office was manipulating its prosecutorial function in order to embark on debt recovery.
So that's one example, and I think 13 contains another example, namely functioning of system causing losses rather than disclosure issues. Where was the issue that you raised in paragraphs 11, 12 and 13 heeded?
Well, there's a question, Mr. Beer, because this was the 2nd of August. Obviously, my terms of reference weren't crystallised until the back end of September. And the review, as you know, or the final review, was dated the 15th of October of that year. I have looked at this and I can't remember what happened in the meantime or whether anybody came back to me, and if so, how, about their views about this or what their responses were.
I mean, to be clear, we're not so much here focusing on the terms of reference for you.
No.
This is you raising issues about the breadth of the Cartwright-King review.
Well, it is that, but I suppose I would have expected if there had been any amendment to this, then I would have seen it in the terms of reference somehow expressed.
Who did you understand to be making decisions about the breadth of the Cartwright-King review?
At that time, Cartwright-King, I suppose.
Did you understand whether civil litigators, i.e. non-criminal lawyers, at Bond Dickinson, were having influence over the breadth of the Cartwright-King review?
All I was, forgive me, all I would say about that is that clearly it was Bond Dickinson, particularly Gavin Matthews, who was communicating with me about the terms of reference. So I assume Bond Dickinson had some contribution to that question.
Can we look at what happened as a result of your raising the breadth of the Cartwright-King review? Poll 00298123. And start by page 3, please. 2nd of August, your email sending through both of your documents dated the 2nd of August, including the second of them, the interim review. Yes, which is the document we've just looked at. And then if we scroll up, please. Simon Richardson says that you're away, but that gives you, Susan Crichton, time to discuss with Gavin Matthews and internally the terms of reference. And then scroll up, please. And a bit more. Yes, thank you. This is Mr. Matthews' reply. You're not copied in on any of these.
No.
This is Mr. Matthews' reply, saying he's now had a chance to review your interim review of Cartwright-King's process, i.e. the document we've just read, and set out mine and Simon Richardson's comments and suggestions for future action. It's clearly good news that the current limited Cartwright-King process if adopted is broadly fine. And then 2, he raises the issue of whether the current review is too narrow. See paragraphs 11, 12 and 13, which I've just read to you. He references the list of issues in the second site report and spot review 22 as examples of other issues which may need to fall within the ambit of Cartwright-King's review. Whilst this should be put to Cartwright-King, my own view is that it may be very difficult for Cartwright-King to expand the review on issues on which second site have failed to come to any conclusion. And then scroll down, please. Our advice is 3, Bond Dickinson, Andy Parsons should sit down with Brian Altman to walk him through the spot review process and the second site report so that he can understand the impact of his review on the civil side.
Sorry, so we're on 3, forgive me, I was
Yes.
reading 1 and 2.
So we read 1 and 2
Yeah,
of the first part and then 3 of the second part.
right. Yeah, well, that didn't happen.
Were the ramifications of widening the scope of the Cartwright-King discussed with you?
No, I don't think they were.
Was the fact that it might impact on the civil side, i.e. on civil claims, raised with you?
No.
Were you ever told that that issue, broadening out the limited Cartwright-King process, needed to be treated with some circumspection?
You mean the what's expressed there in point 3?
Yes.
No.
In your interim review, we've seen that you were alive to the fact that Second Sight was raising questions which were unanswered,
Yeah.
may need following up, hence your paragraphs 11, 12 and 13.
Yeah.
But here the Bond Dickinson seem to think otherwise, don't they?
It appears to be so, yeah.
Did you meet Andy Parsons, as is suggested here, that there should be a sit-down with you to walk through the Second Sight report so you can understand the impact on the civil side?
What's the date of this email, please?
If we scroll to the top,
Is it 5th of August?
it's 5th of August.
Well, the only way I can answer that, and if it was contemporaneous, is you've got my work log, I think, for that period. And I think you'll find the first conference I ever had, and it's work record 1, was the 9th of
The 9th of September.
Yeah.
So outside of that,
Well, beyond it, yeah.
I'm sorry,
The 9th of September postdates this email by several weeks.
yes. So outside of that, what is contemplated here, that the civil lawyers sitting down with you,
Oh, a civil lawyer. Yeah, Andy Parsons, you mean?
yes,
If I had such a conference, it would be reflected in my work record.
and so that didn't happen.
I have no recollection of anything like that happening, I'm afraid, no.
So what happened to the point that you raised in your paragraphs 11, 12 and 13 about the broadening of the Cartwright-King review?
I don't know.
What happened when you realised, as you must have done, that your suggestions had not been followed?
Again, at this distance in time, I just can't remember.
Did you ever get a sense of a lurking difficulty here, that the things that you were suggesting ought to occur for the purposes of the criminal law were causing the civil lawyers some concern?
Well, this is the thing, Mr. Beer. No. I cannot remember anybody saying to me, Brian, if you advise this, this is going to have an impact on civil liability. I don't recall anybody saying that to me. Because if I had, there would only have been one answer.
Which would have been?
That I am afraid that the advice I give you on disclosure will have no bearing on your exposure to civil liability.
But at all events, what was contemplated by the civil lawyers here, namely a sit-down and a walk-through of the impact of your activity on the civil side, did not occur, no, to your recollection?
On this occasion, I'm going to go further and say it didn't happen.
Thank you. Can I turn to my third topic then, the cut-off date,
yep,
of the 1st of January 2010,
yes,
and in particular, SEMA Misra's case.
Yep.
This document can come down, thank you. Now, I think by the time you came to write your general review in October 2013, you knew that SEMA Misra had been convicted of a criminal offences in October 2010.
Yeah, but she had also, of course, pleaded guilty to offences of false accounting in 2009.
Yes. And by the time you came to write your general review in October 2013, you were aware, I think you'll agree, of a wide range of material that undermined the Post Office's key witness in the case against her, Gareth Jenkins.
Yes.
And by the time of your general review of October 2013, you knew that it was Gareth Jenkins who had given live oral evidence against SEMA Misra.
Yes.
And most significantly, you were in possession of the 15th of July Simon Clark advice.
Yes.
On reading the Clark advice, you didn't disagree with the conclusions that Mr. Jenkins' conduct was in breach of duties to the court as an expert, and that his credibility had been fatally flawed. Indeed, you agree with them.
I do.
And you didn't disagree with the advice that there were repercussions for past and present prosecutions and repercussions for past convictions. Indeed, you agreed with them.
Yes.
The Clark advice was amongst the papers that you received, a very significant document, wasn't it?
It was significant advice, yes.
It had obvious implications, didn't it, for the safety of convictions in which Gareth Jenkins had given trials in which Gareth Jenkins had given evidence, whether in a witness statement or oral evidence.
It had significance for, in terms of disclosure, and a possible impact in some cases on safety, yes.
It wasn't restricted to that, was it, though? It also opened up the proper functioning of the system, namely the disclosure of bugs by the Post Office.
Yes.
You agree that the information contained in the advice was disclosable on the basis that the Post Office had allowed, I'm going to use a neutral expression there, had allowed misleading evidence to be adduced in a number of trials, in written statements, and in one case through live evidence, promoting the safety of the Horizon system and even allowing a defendant to be convicted on the back of that disclosure failure?
Well, I think it's the same question you're asking me, Mr. Beer, about what I've already accepted, that his credibility should have been considered for disclosure and disclosed with the benefit of hindsight.
And I'm asking it specifically now through the lens of the SEMA Misra case.
Well, the SEMA Misra case is slightly more complicated, I'm afraid, because at that time, as I said earlier, the focus was on Horizon Online, her branch was affected, or the theft count was, if my memory serves me, between 2005 and 2008, so it was a legacy Horizon issue. And I accept that when we came to the appeals all those years later, the landscape was completely different. But at that stage, I think one of the problems was that, and perhaps taking a naive view, that the two new bugs, and I only knew about three, I think, at that time, Calendar Square or Falkirk, which was a legacy bug, and the two new bugs in Horizon Online, which had been revealed to Second Sight and which they had reported on, I felt could not be material in her case.
And what I'm going to explore over the next, I think, half an hour or so is the change of view.
Yeah.
Between what the position you took in mid to late 2013,
yeah,
and then the position adopted in the Court of Appeal 7 or so years later.
Yeah.
So by the conference on the 9th of September 2013, you knew that Mr. Jenkins was the sole expert witness for the prosecution in SEMA Misra's trial, because I think you'd read the transcripts by then.
I think, I mean, it's hard to recollect exactly what I had seen, but there's no question I had seen some transcripts because the conference...
I'll try and help you on this.
Right.
Let's look at poll 406485. This is one of two notes of the conference on the 9th of September 2013.
Yep.
And you are recorded as opening the conference by confirming that you had read through all 5 of the ring binders delivered by Bond Dickinson. And then if we go to page 3, please. And the second paragraph, you're recorded as saying that you required a full transcript of day 6 of SEMA Misra's case. The copying had only copied every other page,
Yeah.
and that was going to be sent on to you. So by this time, you had got into the detail of SEMA Misra's case.
I certainly read it, yeah.
Yes. Can we see, according to the other version of the minutes, what you said or were recorded as having said about SEMA Misra's case? Poll 00139866. Notes of the meeting with you on the 9th of September, and you'll see who was present.
I've only seen this note in the past few days.
I'll take it slowly then. Again, a similar start. QC, that's you, said he had read all of the papers. And then if we go to page 6, please. And about a third to a half of the way down where it says QC. If that can be highlighted. QC, this is you. Misra concerned. Pre-Horizon Online case. Issues were detailed, as I've seen. She went to prison. Jenkins gave evidence. Training and Horizon issues. Professor McLachlan, much of it hypothesis. That is a case slipping through the net. Susan commented that she'd applied for mediation. You say, how are we going to deal with it if she comes forward and says similar? Susan Crichton says, either review all pre-2010 cases or we do nothing and wait for them to come forwards. You say, next problem, what disclosed? That's Roderick Williams. We will always have people who want to go back, and if we do, trying to prove a negative. you're recorded as saying, can't avoid the question. Provisional view, a sensible date to adopt, but can't avoid the possibility that Misras may crawl out of the woodwork. Deal with on a case-by-case basis, unless someone states cut-off is unreasonable. Does this record of this conference fairly reflect your view that the cut-off date of the 1st of January 2010 was sensible to adopt, but that there was a possibility that Misras might crawl out of the woodwork?
As I say, I've seen this conference note for the first time in the last 7 days, and I didn't have an opportunity to look at it all those years ago. But I've no reason to think that it's inaccurate.
And just scrolling up a little bit, where it says slipping through the net, can you see that?
Yeah.
That the Misra case might be a case slipping through the net. Was that an acknowledgement that Mrs. Misra's case fell outside the parameters of the review that you approved?
I mean, on one interpretation, and if if the note is accurate, answer yes.
Was the cut-off date a principled decision rather than an attempt to close down complaints and prevent the floodgates from opening?
Not from my perspective.
Did you gain any impression that from the post office's perspective, the cut-off date of the 1st of January wasn't a principled decision, but instead an attempt to close complaints down and prevent the floodgates from opening?
I mean, I dealt with this, you'll recall, in my general review, and I made comments in various places about Cartwright King keeping their mind open.
I'm going to come, if it helps, to
I'm
the
sure,
general
I'm
review
sure
at the
you
moment.
will, but this was always my thinking. To answer your question, I remember making some comments about Simon Clarke's view about the cut-off date, and I had some views that some of the factors he brought to bear on that decision were nothing I could support and did support.
And we'll see that in a moment when we look at the general review. You say some of his logic was not supported.
Yeah, I'm sorry, I know I'm jumping ahead, but to answer your direct question, I don't recall getting the impression that Post Office saw it in the way that you suggest they might have done.
So can we take our second break? At that point, please, I'm going to come back to this meeting after the break. Until 25 past, please.
You read my mind, Mr. Beer.
Thank you, sir. 25 past. Good afternoon, sir. Can we go back, please, Mr. Altman, to the note of the conference of the 9th of September 2013, poll 0013 9866. And page 7, please. Sorry, page 6. So about halfway down. Thank you. And your recording as saying, in relation, I think, to Miss Misra's case, that it is a case slipping through the net. And then Susan Crichton replied, or she commented, that she, that's Miss Misra, had applied for mediation. Yes? Would you understand that to mean, or to be a suggestion, that she wasn't slipping through the net entirely, because after all, Mrs. Misra had applied to be a party to the mediation?
I'm not sure I would have, at least at that time, have linked the two, my comment and hers.
You subsequently advised against the inclusion of Mrs. Misra in the mediation scheme, didn't you?
Yes.
And so to the extent that this is a suggestion by Susan Crichton that she wouldn't slip through the net, your subsequent advice had the effect of meaning that she would slip through the net and the mediation scheme would not save her.
Well, you could infer that from this, but I suspect at the time that I was thinking about Mrs. Misra and the mediation, my view was principled, that clearly I was concerned that she was a case slipping through the net, but my approach to mediation, not just for Mrs. Misra, although she was the name that was put to me, I don't remember any other names of any other postmasters being put to me other than hers. But mine was a principled approach to it.
But you would agree that despite that principled approach, it would have the effect of excluding Mrs. Misra from the mediation and thereby obtaining any information
Yes.
through that route.
I'm harsh though it may appear and unpalatable after all of these years, that is and was the effect of it.
And if we read further on in the attendance note, if we scroll down, please. You say can't avoid the question, and then reading on to where I stopped off, you're recorded as saying, so any individual for 2005, I was prosecuted and pleaded guilty. And then you said, recorded as saying that Mrs. Misra was unique.
Yeah.
Did you regard her case as being unique?
Well, there are two words there, which I take it this is Martin Smith's note, that he recorded, which I didn't see at the time. If I use the word unique, I'm prepared to accept I might have done, but whether it was simply a single word response like that or there was more to what I said, I can't tell after all of these years. Then it could have related to the fact that she was the only case in which Gareth Jenkins had given evidence.
And what was the significance of that? What were the consequences of that?
Well, I don't, the trouble is in the context of a note like this, I can't tell you. But the consequences were that I suppose she wouldn't know that Gareth Jenkins had revealed what he had to Second Sight. I suppose looking back with hindsight after all these years. But the trouble is looking at this note and the way it flows. And if we carry on, perhaps.
Yes, we go over the page, please.
If you would, because I think there's more context to this. I just wonder whether it was part of the conversation about the mediation.
What, the fact that she was unique was a...
Well, Mr. Beer, you're asking me about a single word in a document I've only seen this week, which I didn't see at the time. And I'm doing my best with what's in front of me. I don't know.
Shall we look at what's about a third of the way down the page there?
Yeah.
It's recorded that Gavin Matthews asked Misra, should we apologise?
Yeah.
And you replied, it is recorded, I wouldn't.
Yes.
Can you recall the question of apologising to SEMA Misra arising?
Well, if Mr. Smith's note is accurate, then it did. And again, if Mr. Smith's note is accurate, I must have said something along those lines. Whether it would have simply been a 2 or 3 word response, I doubt very much.
Looking back now, can you think why you would have advised not to apologise
Yes.
to SEMA Misra?
Yes, I can. Because for 2 reasons. It wasn't just about the fact that she had been convicted of theft, but she had also pleaded guilty to several offences of false accounting in 2009, which at that time, on what I understood, could not be related to any issues with Gareth Jenkins. And therefore, if Mrs. Misra was admitted to the mediation, as a point of principle, I just couldn't begin to understand why, in some form of quasi-civil process, Post Office wanted to ride both horses at the same time. Here they were saying, this conviction is safe, and those pleas of guilty are safe. And at the same time, we want to engage, or we could engage in mediation with her. I just didn't understand the idea of apologising to somebody, Mrs. Misra, as it was understood at that time, and at the same time potentially talking about financial compensation. So it was a principal point. I'm afraid her pleas of guilty, the convictions arising out of those pleas of guilty and the conviction for theft, were, like everybody else who were convicted claimants, were unoverturned at that point. And it was for the Court of Appeal to disturb those convictions, not the mediation scheme.
You addressed these issues in your general advice. Can we turn that up, please? Poll 406581.
6581.
Poll 406581.
We had 6803, I think, before.
Yes, we've obviously got it
Never mind,
twice.
it's the same document.
And can we look at page 23, please?
Page 23.
Yes.
Yeah.
And from this point, page 23 onwards, under the cross-heading Nature and Scope of Cartwright-King's review, you, in broad terms, in summary, address the scope of the review,
Yeah.
looking at geographical extent, temporal extent, and other issues, correct?
Yes.
And then if we go, so if we look at 58, the nature and scope of the review was defined in Simon Clarke's 8th of July advice, which coincided with the day of publication of Second Sight's report. The advice was that cases affected, including Royal Mail Group cases pre-separation, and the areas of concern were the proper functioning of Horizon training and customer support. And then if we go, please, to over the page, and I'm afraid it's going to be necessary to read quite a bit of this, from 61 onwards, you address the temporal scope of the review. There was also consideration to the start date of the review. Horizon Online was migrated into all post offices between January and September 2010. Thus, the advice given was that the start date for the review process should be the 1st of January 2010. That's to say the earliest date for the Horizon Online rollout. Mr. Clarke advised in an advising on this date, he had in mind issues of proportionality, resourcing, transparency, and the post office's reputation. Just stopping there, were they proper or all proper reasons to focus on when deciding whether to look for material that may disclose a miscarriage of justice?
I think I dealt with this, didn't I, in the general review, where I said that they weren't proper factors.
Yes, and so the 4 factors set out there,
Yeah.
proportionality, resourcing, transparency, and reputation, which of them were not proper factors?
Well, if all 4 were designed to identify the 1st of January, as the start date, as it were, for the review, all of them.
So that none of them is a proper factor.
I didn't think so, and I'm sure, I think I said that a little earlier, Mr. Beer, at 63 and onwards, I think I deal with this.
You come on to address some of them.
Yeah, or some of them, but I didn't think any of them applied, and certainly not Post Office's reputation.
No. So in deciding how far back to look on whether exists material relevant to a miscarriage of justice, the Post Office's reputation is not something to bring into account.
It was nothing to bring into account, and that's why I said what I did.
You record in 62, Simon Clarke's view was that any sub-postmasters prosecuted under the former Horizon regime would have served any sentence of imprisonment or performed any unpaid work requirement or paid a fine, and at all events, the publicity from Second Sight's report will put those defendants on notice. And in 63, you record that the appendices in the Second Sight report are posted on the website. And then line 3, you say, I'm afraid I do not see those who have served their sentences, etc., should for that reason be excluded from the review. They have an interest if their conviction was unsafe. And there must be people who fall within the current review who've been released from their sentences or had non-custodial sentences imposed on them. So you're saying that that element of Simon Clarke's reasoning, that all these people have done their time, is illogical and can't be relied on.
Yeah, I mean, with respect to Simon Clarke, I just didn't, I frankly didn't understand those points. And then, as you'll see, I dealt in that final sentence with 2 other of the factors which I'd listed above, resourcing and the reputation.
Beside the point, correct. And then you continue, when I queried the rationale behind the cut-off date, I was told and entirely accept that prior to each branch rollout, a cash audit was done so that each branch balanced. I advised in conference, and repeat here, although Post Office has no positive duty to seek out individuals before the 1st of January 2010 start date for a review of their case, nonetheless, if Post Office was approached, it would need to make ad hoc case-specific decisions about the need for disclosure. The Misra case is an example of the case I have in mind. Although she was tried in October 2010, allegation related to events between 2005 and 8, long before the rollout of Horizon Online. However, the issues raised in the case, which were made late by the defendant in one or more defence statements, were very similar to those generally being raised currently in the Horizon Online system. She was eventually to claim that the approximate £75,000 deficit in her office was due to a technical error or her own incompetence, having initially sought to blame employees. There's no information that Mrs. Misra is now seeking to appeal her conviction, although she is seeking to participate in the mediation process. 67, there are currently 12 or 13 conviction case applicants. And then over the page, you've considered Second Sight's inquiry. You note it is not time limited. The definition of horizon that Second Sight relied upon is widely drawn. And you note in the last 3 lines of that paragraph, the spot reviews, or several of them, involve horizon issues predating 2010 rollout of Horizon Online. And then 70, despite the open-fronted nature of Second Sight's inquiry, it's important to recognise that Second Sight has only so far discovered and reported on 2 Horizon defects, respectively occurring in 2010, which you assume to be a defect with Horizon Online, and 2011. And then your conclusion, in my judgment, the 1st of January 2010 start date for Cartwright King's review is both a logical and practicable approach to take. That's not to say if a case predating the Horizon Online rollout presents itself that CK should exclude it from consideration. There may be cases that raise genuine, thorny technical issues which are not unrelated to issues concerning Horizon Online, which, after all, is next generation Horizon. If they arise, they'll have to be dealt with as required on a piecemeal basis. If it got to the stage where the floodgates of pre-Horizon Online cases began to open, then the Post Office and Cartwright King will have to remain alive to the possibility of commencing a subsidiary review. So you say that the cut-off date is logical and practicable. Dealing with practicability first, why was it practicable?
I think it was practicable because the bugs which had been revealed to Second Sight and reported by them in the interim review were accessible in the sense that they were more recent. And second, I have in the back of my mind that there was some problem in going back to legacy Horizon and understanding what might have happened with that system.
Where did you get that understanding from?
I am sure I knew about that. I know I don't say it here, but I'm sure I knew about that.
What was the nature of the thing that you knew about?
Simply, I think that was the system archived or not live anymore, something like that.
In terms of the logic, you say that it is a logical approach to take. In saying that it was the logical approach to take, did you take as your starting point the assumption that there were no bugs in the old Horizon system?
No, I didn't take that as an assumption because I knew that there was one, which was Calendar Square. But I suppose it was looking at the two new bugs which had come to light. Calendar Square or Falkirk had been litigated in the course of Mrs. Misra's trial in 2010 and was to that extent in the public domain. These were two new bugs. And they were two new bugs in Horizon Online. And that came online and was migrated to branches from the 1st or by the 1st of January 2010. And that was the logic to it.
The balance of 71 is essentially a way of saying that if any other cases crawl out of the woodwork, isn't it?
Yeah.
We'll face them when they arise.
Well, I think that's a rather harsh judgment, Mr. Beer, because I think what I'm really saying is I'm saying to Cartwright King and Post Office for that matter, you must remain alive to the possibility of commencing a subsidiary review. So, to the extent that I did use that term in the course of the 9th of September meeting, I mean, this document is the 15th of October, so it's 5 or 6 weeks on, and my thinking had moved on. And I recognised, and I wanted Post Office and Cartwright King to recognise, that if there is a legacy Horizon system problem, then you're going to have to potentially consider commencing a subsidiary review. That's what I meant by it.
Can we look at a stepping off point between the 9th of September conference and the 15th of October general review? Namely an email of the 3rd of October, poll 0006 6825. This is an attendance note from Martin Smith of Cartwright King of the 3rd of October 2013 of a conversation that he had with Gavin Matthews of Bond Dickinson. So this is after your September the 9th conference, but before your 15th of October general review.
Yeah.
The summary telephone call Gavin Matthews, he's spoken to Brian Altman QC. Detail telephone call Gavin Matthews, he's spoken to Brian Altman QC. Mediation cases can go on separate spreadsheets. So far as date is concerned, understand why the 1st of January 2010, but on the basis no bugs prior to then on old system. He advises only need to review Horizon Online cases since that date. Martin Smith says he's not sure that is correct. HB currently looking at Misra transcript to see what Gareth Jenkins said.
HB, Harry Bowyer?
Probably.
Yeah.
Think it likely to contain a reference to the Misra bug. Gavin Matthews suggests that you may well have advised on the basis of an incorrect assumption. Martin Smith said he would call tomorrow. And then the rest is about something else.
Right.
Are they right that you advised on the basis of an incorrect assumption that there were no relevant bugs pre-Horizon Online?
I can't see that's possible. I can't see that's possible because by the 3rd of October, as you pointed out earlier, I'd read transcripts from the Misra trial.
Did either of them raise their belief that you were advising on an incorrect basis with you?
No, I saw this as part of the disclosure to me. Frankly, I can't remember if it's in my original bundle or the additional documents, but it doesn't matter. I was totally unaware of this.
And so Mr. Smith did not call you the next day, to the extent that that's a reference to him going to call you the next day?
Well, I don't want to say no without looking at my work log, which would only be fair. The next
Be the 4th.
4th of October. Yeah. So I had a conference call with Gavin Matthews, Cartwright King and Post Office for half an hour.
On the 4th?
On the 4th, but as you will know, that related to the scope of the review, and that is recited in the general review. But I don't recall anybody suggesting to me, you've misunderstood.
Thank you, that can come down. Sitting here today, do you stand by the advice that the correct cut-off date was the 1st of January 2010?
Yes, on the basis of my understanding at the time, which did, in my mind, it must have included, I knew about the calendar square bug in Legacy, and that was the only bug I knew about in Legacy. Yes, I do.
And the corollary of which is that the Post Office should do nothing in relation to sub-postmasters convicted before that date, and instead wait to see whether they came forwards.
Yes, and that was based on mixed fact and law. The law has never been post-conviction that a prosecutor has to go out and search for cases which may be unsafe on the basis of little or no information. And that was confirmed, actually, not at that time, but I'd always understood that to be position. That was confirmed in the Supreme Court in the case of Nunn in 2014.
Had you not given consideration at this point to the fact that you regarded Mr. Jenkins as an unreliable witness? He had been a cornerstone of the case against SEMA Misra, and that at least in her case, there ought to have been such disclosure.
5th time of agreeing with you, Mr. Peer. I've made that plain. Yes, I can see that.
What accounts for the failure?
If I cast my mind back, I think the only thing that would have gone through it is the fact that the failure by him was to identify in her trial bugs in Horizon Online, which would not have impacted.
You told us today that your concern about admitting people like SEMA Misra to the mediation scheme was that they remained convicted defendants. The mediation scheme could do nothing about that.
Yes.
Only the CACD could.
Yes.
Can we look, please, at poll 406485? This is the other note of the conference on the 9th of September.
Yes.
And if we scroll down, please. And keep going. And keep going. Thank you, keep going.
Which page do you want, Mr. Beer?
I think it's on the second page. Stop there. Yes, it's the On the screen, it's the second paragraph from the top. No, sorry, the wrong paragraph. If we keep reading, please. Keep going on the scrolling. Yeah, there. Third paragraph. There was then a discussion in relation to the overlap between the intended mediation process and criminal cases. Andrew Parsons reported the current position in relation to the mediation process and how it was intended to work. Individuals currently being prosecuted are not eligible, though individuals who've previously been convicted are eligible for the scheme. And you're recorded as saying that you advised considerable caution in relation to mediation cases involving previously convicted individuals. SEMA Misra has already indicated an indication to be within the scheme. The concern is that lawyers acting for those individuals may be using the scheme to obtain information they would not normally be entitled to in order to pursue an appeal. Is that, so far as you can recall, an accurate summary of your advice as to why convicted individuals should not be admitted to the scheme?
That wasn't my advice at all. My advice was that there should be caution in relation to the mediation cases, and that was for the reasons I've already given. The way this is written may suggest this was my advice. It wasn't. The concern that lawyers acting for those individuals may be using the scheme to obtain information they wouldn't normally be entitled to was Cartwright Kings or post offices. It wasn't my concern, as I made clear in subsequent paragraphs in the advice I later gave.
This doesn't record as the reason for not admitting sub-postmasters who have been convicted to mediation.
No.
That they remained convicted.
No.
It's recorded as you expressing a concern about lawyers getting information to which their clients are not entitled.
No, I'm sorry, but that is a misreading, or it's an unfortunate juxtaposition of two sentences. The first was my advice. This one doesn't say BA said. This one said the concern is that. And I made that clear in my witness statement. And if you go to the general review, you will find me expressing, perhaps more accurately than this is prepared to do, that the concern, in fact, I think I used the words understandable, but that the concern was Cartwright Kings. And if my memory serves me, I think you'll find that in paragraph 129 of the general review.
And so this paragraph in the conference note, which I think you did have an opportunity to settle at the time, didn't you?
No, I don't think I did.
You weren't sent this to
I'm not saying I wasn't
amend.
sent it, but I don't think I was sent it to approve. And frankly, if I'd have looked at it, obviously, all these years after, one can go through it with a fine-tooth comb as we are. But even if I had, I don't think I'd have done that or looked at it with any particular, unfortunately, using the word concern. But I can tell you categorically that second sentence was not any concern I advised on. It was not my concern, it was theirs.
And so this should either be a new paragraph after the end of the words "the scheme," and beginning with the concern.
Well,
and it should read, Cartwright King held a concern.
If I was writing it and I'd applied my mind to it, if you think that this was me saying it, I'm afraid, Mr. B, you're very wrong. I was not. And as I say, I made that perfectly clear when you come to look. As I say, I think it's paragraph 129 of the general review. Because this was an ongoing theme. And I think 129 is where I recite the conference we've just been looking at of the 4th of October. It's the same thing. And, and if you look in that paragraph, I think I'm right in saying it's 129, you'll see I set out exactly the same words, almost. That it was Cartwright King's concern.
Did you say to them, that's an improper concern to hold?
I think what I said is what appears, again, in somebody else's note in the paragraphs that follow.
Were you concerned at all about the need for the Post Office or Cartwright King to take control over what Second Sight was disclosing in the course of the mediation process?
Yes, it was about supervision, and it was about controlling the information disclosed or being disseminated to individuals who were within that scheme, not being blindsided by evidence that they were not aware of, and auditing the information, which, in my experience, is no different to what any prosecuting authority does in any disclosure process. And again, actually, Martin Smith's note on this occasion sets it out pretty clearly, because I had said, I think it may be page, I can't remember now, page 8, possibly page 6, where he noted that I said that there should be a sharing of the information and it should all be recorded by Cartwright King. That's what I was talking about.
You weren't concerned that Cartwright King or the Post Office should control what Second Sight was disclosing in the course of the mediation process? I
felt there was a risk, as I recall it, that Second Sight, this was an uncontrolled environment. So I felt there was a risk. And that's why I gave the advice I did. This wasn't about not disclosing. This was simply advice about supervise what's happening so that you know what's going out of the door. It was as simple as that. A record, an audit trail, you know what's being disclosed.
Can we look, please, at poll 0033 7202? This is an email from you to Gavin Matthews about a fortnight after the conference. The first page concerns the terms of reference. Can we look at the second page, please? Regarding the conference note, I think that's the conference note for the 9th of September, it accords with my recollection, except in a case of a couple of matters listed above. And then as to the final paragraph of the draft conference note, I did advise that Cartwright King needed to rethink the terms of the letter they're sending out. And then I also recall advising, one, there was no positive duty to seek out individuals before the 1st of January 2010, but if the Post Office was approached, it would need to make case-specific decisions on disclosure. And secondly, you recall advising about the need for the Post Office and Cartwright King to take control over what Second Sight was disclosing in the mediation process. Why was it necessary for Cartwright King to take control over what Second Sight was disclosing?
Well, for the reasons I've already given, that I wanted to ensure that Cartwright King, as Post Office's external solicitors, understood what material was going out to postmasters.
That's a slightly different issue, isn't it? They should have visibility of what is disclosed.
No, it's the same thing. I spoke in terms, I used the term control and supervision pretty interchangeably. It was, I wanted them, and I've already said this, what Second Sight, I think, or what I understood was doing, was uncontrolled. I wanted Cartwright King to know what was being disclosed.
So it's 1 o'clock. Might we take the lunch break? And
yes.
10 to 2, please.
10 to 2 is a truncation of the transcriber's lunch break in any event. How do you foresee this afternoon going, Mr. Beer?
I envisage going until about 20 past 3, and then some questions from call participants.
And so we need to have 10 minutes less for lunch, do we?
I'm afraid so.
All right, then 10 to 2.
Thank you, sir. Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you. Good afternoon, Mr. Altman. Can we turn to my fourth topic, please, which is the legal advice you gave in relation to the Post Office's investigation and prosecution roles? And can we start by looking at your advice on this issue, which is Poll 406802. This is dated the 19th of December 2013 on its last page. I just want to ask you about a couple of parts of it. Can we start by looking at page 4, please? Again, you provide an executive summary, and under paragraph 5.1, you say, I've seen no evidence to suggest that the Post Office exercises its investigations and prosecution function in anything other than a well-organised, structured and efficient manner through an expert and dedicated team of in-house investigators and lawyers supported by Cartwright King and their in-house counsel, as well as external counsel and agents where required. How did you come to the view that the Post Office was exercising its investigation function in a well-organised, structured and efficient manner?
I think based on what Post Office had sent to me, I had met Cartwright King, I had met Roderick Williams, I'd met Jarnail Singh once, maybe twice, and I had read by that stage certainly 2 of the prosecution files. I had more insight into Post Office through the general review. And I think the overarching view I came at was is reflected in that paragraph.
Focusing on the functions performed by investigators and your conclusion there about them, had you examined any documents or material relating to the training of investigators?
I've got an idea I might have asked for something, but I can't remember.
Had you examined the knowledge and experience of Post Office investigators?
I think I knew that some of them were former police officers.
Was that the extent of it?
I can't remember.
Had you examined the investigators' knowledge of and practical application of the law of disclosure?
The investigators?
Yes.
No.
Had you examined the extent to which investigators actively investigated all reasonable lines of inquiry, including those which pointed away from the guilt of the suspect?
No.
Had you investigated what supervision, checks and balances, if any, existed to superintend the work of the investigators?
Well, I understood that Cartwright King were involved as the external agents, and I understood that they were the instructing solicitors, and I had met Simon Clark and I'd met Harry Bowyer, and I remember being impressed by them.
That's being impressed by lawyers. I'm asking at the moment about superintendence or supervision of the work of the investigators.
No, but I rather thought that Cartwright King had that superintendence.
Had you examined how in practice decisions as to whether to prosecute or not were made in practice?
No.
Had you discovered who the decision maker was in relation to any decision to prosecute?
Well, if my memory serves me, during the course of this review, I had referred to several Post Office policies, and I think one of those policies put the hands of the ultimate decision-making in the hands of somebody who was non-legal.
Had you examined...
So, forgive me, so
Yes.
I made a point about that.
Had you examined what the training or experience of that person was?
Of that person, no, but the point I made, I think, was it ought to be in the hands of a legal individual.
Did you examine how much consideration that person gave to an analysis of the evidential strength of a case?
No.
did you examine what tests that decision maker applied when deciding whether a case was to be prosecuted?
No.
Given all of those things, how were you able to say that the Post Office exercises its investigatory function in a well-organised, structured and an efficient manner?
I think I was talking more about the hierarchical structure and what had been presented to me in the way that the Post Office, through those various policies, was structured. I don't think I was deep diving, nor do I think I was expected to deep dive all of the factors that you've just mentioned. If I had, this would have been a completely different exercise.
Do you think there was a danger in the conclusion that you wrote there being misunderstood and therefore misapplied and being used as a weapon by the Post Office in fending off criticisms of it?
On the basis of what I've just said, yes, I can see that. At the time, I suspect I didn't appreciate that it would be.
If we go forwards, please, to page 39. And paragraphs 105, 6 and 7. You say that it may be thought that the Post Office prosecution role is anachronistic and highly problematic. 106, the recent events have to be seen in the proper context. The serial non-disclosure of relevant material occurred in circumstances in which the Post Office asserts that it and its advisors were wholly unaware that there might be disclosable material or information, and so whatever the reason, were not placed in a position whereby they knew of its existence and could deal with it appropriately.
Yeah.
You tell us in your witness statement that later events proved your information and understanding that you set out there to be wholly incorrect.
I think I said catastrophically incorrect.
We'll just check that.
Which paragraph do you have?
41.1 on page 21.
Certainly somewhere I recognised it was catastrophic, or that the information I had afterwards, but not then. Yeah, no, it's not in that paragraph, but certainly somewhere else I say that.
Page 21 at the foot of the page, please. Bottom of the page. The paragraph that I've just cited from your advice is followed with the sentence, later events proved my then information and understanding to be wholly...
No, you're right, but I'm fairly sure somewhere here I made the similar point, but somewhere else.
That it was catastrophic.
Catastrophic, yeah.
Can you please set out what you now know that demonstrates that the information upon which you were advising was wholly incorrect? Firstly, in terms of the Post Office being in possession of disclosable information.
I'm afraid I can't give you detail because it's so complicated, and my knowledge has developed over the course of the years, up to and including the appeals in March 2021. But what I discovered in later years, and by later years I actually mean the Horizon Issues trial onwards and that judgment, was the landscape, as I called it earlier, was entirely different, that it was perfectly clear to me that individuals within the Post Office were very well cited on all of the problems. Some of them you demonstrated during the course of your examination today. And, I look at paragraph 106, which I've read more than once, as a remarkable insight into my ignorance and what I wasn't told and what I didn't understand.
In terms of the Post Office being, quote, wholly dependent on Fujitsu and or the expert to reveal material so that Post Office could perform its prosecution duties, who provided you with that incorrect information?
Sorry, which paragraph is that?
It's highlighted on the screen.
Oh, sorry.
It's a citation
from
your advice. Post Office was inevitably in a position where it was, quote, wholly dependent on Fujitsu and or the expert to reveal material so that Post Office could perform its prosecution duties. And I'm asking who provided you with that material, that information?
I just don't know, but it was clearly something that was in my mind at the time that I wrote this.
Was that, in fact, not information that was provided to you, but rather a conclusion which you drew by reading the material that you had been given? i.e., it's your subjective assessment?
Perfectly possible that it's an inference from everything I saw.
Thank you.
Or everything I was told, or perhaps not told.
That can come down, thank you. Were you told about a possible plan to transfer cases to the CPS to consider for prosecution?
What, the Post Office had a positive plan to do that?
Yes. Or was considering whether to do that?
Well, I think it was something obviously I looked at in this review document. Whether I did it off my own bat or whether somebody suggested to me, is this something we should be looking at, or further than that, there is a plan to do this, I simply can't recall.
Can we have a look at an email exchange, please? Poll 0014 7419. You'll see this is an email exchange that you're not included on. It's from Roderick Williams, litigation lawyer at the Post Office, to Chris Oyard and others, dated the 11th of January 2014. And it's a summary of what he says was his discussion with you earlier that day.
But which obviously postdates this review by a month or two.
Yes.
Yeah.
And can you see that under A, just in passing, you seem to have advised in the last bullet point, board minutes or discussions about pursuing a prosecution policy for commercial aims may need to be disclosed. If the application of that policy was ever called into account, this presents a risk of reputational damage.
And the key message beneath that?
Yes.
Yeah.
Where it records a key message, do you think that's him summarising a key message that you told him, Roderick Williams?
Well, I think it's the penultimate bullet, the one above the highlighted one.
Yeah. And so where it says key message, that's essentially something that you said or would have said to Mr. Williams?
Well, Chris, here's a summary of my discussion with Brian earlier today.
What I'm just looking at the moment is the attribution of words here and whether or not
I see.
The key message is something that is Mr. Williams setting out his key message or setting out your key message.
I suspect that's his key message, his takeout from his understanding of the advice I'd given that day.
But based on what you had advised. Yeah. I understand. And can we look, please, further down the page to B, jumping from A, status quo, to C, all CPS.
Yeah.
A change of policy is not an admission that past practices were wrong. It would still be open to someone, e.g. a conspiracy theorist, to say this did drive the change, referring to the temporal connection between the change in policy and the challenge to past prosecutions. This could lead to inquiries about the reasons for the change, e.g. requests for disclosure or questions in Parliament. It's far from certain the CPS would take on any of our cases given the budgetary pressure it's under. We should start discussions at a high level within the CPS if we want to take this on. I don't just announce that the CPS is going to prosecute criminal conduct in our network without raising it with the CPS first. We should not lightly give up or cede to another our expertise in identifying and, where appropriate, prosecuting criminal conduct in our network. Key message, jumping from A to C risks sending the wrong message to the network about how we view criminal conduct, both past and present, and losing our expertise in monitoring our network without any certainty that prosecutions would be picked up by the CPS. However, a change in policy, however dramatic, does not present a pure legal risk of challenge to past convictions. Does that accurately record the substance of the advice that you gave?
I can't say it. I can't say it does, and I can't say it doesn't. Not least because I have to say, when I looked at this email, I was not totally convinced. I was prepared to accept that I had given the advice in the conversation under A, but I looked at B, and when I first looked at it, I wasn't sure that that was what I had said. But so I can't answer that question, I'm afraid. I don't remember this conversation at all, this part of it anyway.
What made you think that it might not be you speaking in relation to the issues under B?
Simply because I wouldn't have said words like, e.g., a conspiracy theorist. I wouldn't have say that this did drive the change, referring to the temporal connection between the change in policy and the challenges to past prosecutions. That's not the way I express myself. So I looked at it and I was not convinced that this was me. The next bullet point, far from certain CPS would take on any of our cases given the budgetary pressure it's under. I know I did have that view, and I expressed it in the review document we've just been looking at.
You saying you think you've been verbaled here?
Sorry?
You saying you think you've been verbaled?
I don't want to be unfair to Mr. Williams. There are possibilities that I had this discussion. I just looked at it. I just didn't think it reflected the way I would express myself. But, it's possible. I just don't know.
In any event, did you advise Mr. Williams that shifting cases to the CPS would, quote, risk sending the wrong message to the network?
I don't think that's something that I would say, because that was a business case, and I don't think, looking at this now, that is something that would have been within my ken or understanding. That was something I think Post Office were very keen on, about the message.
What message were they very keen on?
Well, the one you just identified about the network and postmasters understanding that we'll pursue prosecutions.
Exactly. So exactly what message were they happy or keen on being distributed to the network?
That if you have your hand in the till, we'll prosecute you.
Thank you. That can come down. Can I turn to the fifth topic then, please, which is the advice you gave about the distinctions or absence of distinctions between offences of theft and false accounting?
Yeah.
And can we begin by looking at poll 406588, please? This is your advice on theft and false accounting.
Yes.
It's dated the 8th of March 2015 on its last page.
Yep.
We just read through some of the paragraphs. First, paragraph 1, you'd been asked to advise the Post Office on my view of the equality of the offences of theft and false accounting under the Theft Act 1968, and to consider the terms of a letter sent by Post Office, the second site, on the 24th of February 2015. And then over to page 2, please.
Do you mind, before you do that, going to paragraph 2, because that's the information I had as to why I was being advised. It wasn't just about the letter.
Of course,
the arguments.
You were told that
Yeah.
second site is beginning to advance arguments that the Post Office is abusing its prosecutorial role by charging sub-postmasters with theft when there's no evidence of it, in order only to pressurise them into pleading guilty to false accounting.
Thank you.
Then over the page, please, to page 2, paragraphs 5 and 6. You say you've been made aware that Sir Tony Hooper has seen the letter. That's a letter sent by the Post Office, the second site. And the gist of what he has said, amongst other things, is that false accounting is a lesser charge than theft. So second site was not incorrect to characterise it as such. He added that, however, that if someone steals, then that is more serious than if someone falsely accounts, to cover up an accidental loss of £10,000, but if someone falsely accounts for, say, £500,000, then that offence is of greater seriousness. And then page 3, please. And scroll down to paragraph 9. You say, first, there's no legal concept of equality of offences in law. All I think Cartwright-King meant by it was that both are offences of dishonesty, carrying identical maximum sentences. This was a generalisation, but in reality means little or nothing. And then page 5, please. Paragraphs 14 and 15. You say, my point is that merely because the charges involve dishonesty and maximum sentences of 7 years is not to tell the whole story of how in individual cases a judge is likely to sentence one from the other. Each case involves a careful process of assessment and of culpability of the offender, harm caused, the aggravating and mitigating factors, and the individual guideline into which the offence fits. If I may say so, the so-called equality of the offences is an unnecessary and unprofitable focal point of attention. The other points raised by the letter have greater force and are defensible. And then lastly, paragraph 22 on page 7. In conclusion, I advise that both offences of theft and false accounting do indeed involve dishonesty and do carry a maximum sentence of 7 years imprisonment. I think the only argument that may be advanced to defend the statement is that it is accurate within the narrow context in which it was stated. The point is that false accounting may be a lesser offence and may be a lesser offence in the context in which it's charged. So to argue it's not a lesser offence is not accurate. It all depends on the circumstances of the individual case, as Tony Hooper's illustrations show. The statement is undermined by the fact that the seriousness or otherwise of any offence of theft or false accounting must always depend on its own facts, as is demonstrated by the many ways in which such offences may be committed and how offenders may be sentenced for them. Do you think you really addressed the substance of the issue being raised, namely that there was an allegation or suggestions being made that the Post Office had a practice of charging theft when there was no or insufficient evidence of theft in order to pressurise sub-postmasters into pleading guilty to the lesser offence of false accounting that had been included on the indictment, and that Cartwright-King had said that Second Sight's suggestion that false accounting was a lesser offence was inexpert and wrong?
No, because I wasn't asked in that advice to address the allegation which I set out in paragraph 2. I was simply asked to address, and that's what I did address in my instructions, the defensibility or otherwise of the letter which Post Office, crafted by Cartwright-King, had sent to Second Sight.
Wasn't the point that in the context of the real world involving cases of sub-postmasters being prosecuted, an alternative charge of false accounting to theft would inevitably be a lesser offence in terms of the likely sentence?
It can be, not necessarily always. It depends on the facts. These are fact-specific issues. But I wasn't asked to state what anybody who practices in crime knows, that people will plead guilty to offences or lesser offences in order to attract a lesser sentence.
But that was the issue, wasn't it?
I didn't think it was.
You confined yourself to the very narrow question of whether technically what your client had said in a letter could be defended.
And that's what I was asked to do, Mr. Beer. If they had said to me, and by the way, Mr. Altman, do people sometimes plead guilty to lesser offences to attract a lesser sentence, I would have said exactly the same. And you will know, because there is an email, that I asked Andy Parsons, who instructed me, to find out from Tony Hooper what it was that he was saying. I wanted to understand what his complaint about the letter was. And he came back to me, he told me what Sir Anthony Hooper's complaint was about the letter, and that is what I addressed. I'm sorry, I disagree.
Were you straining here to help Cartwright King out and not advising on the obvious issue that in this context of counts charged as alternatives to each other?
No, I'm sorry, Mr. Beer, that for me is a complete misreading, and I say that with great respect, of what I was asked to do in this advice and what this advice confronted. If I had been asked to advise on the question you would like me to have been instructed on, I would have responded. And in response to your other points that I was helping out Cartwright King, I don't see how I was when you read out what I said in paragraph 22, including the point is that false accounting may be a lesser offence and may often be a lesser offence in the context in which it is charged, so to argue it's not a lesser offence is not accurate. And it's absolutely accurate, as I continued here, to say it depends on the circumstances, as Tony Hooper's illustrations showed. So forgive me, I fundamentally disagree.
And so you didn't think it was part of your function to make the obvious point?
No, because it is an obvious point, and Cartwright King would have known it, and anybody else would who practices in crime. I did not for 1 second think I was being asked to advise on that. What I was being asked to advise on is exactly what I set out, is this paragraph. In other words, have we got this right? So Tony Hooper is saying this is nonsense. Cartwright King has given us this advice, and that has been reflected in this letter. Are we right or are we wrong? And the product of my advice is in the conclusions in paragraph 22. That was what I was asked to do.
Wasn't it clear to you that Sir Tony Hooper was taking the point that it's really an irrelevance to say that the two offences are equal to each other by simply looking at whether they contain as an element dishonesty and whether they have the same theoretical maximum sentence?
No. I mean, if you want to look at the email I got, I know you have it. It's a B31. But the email I got, because I was keen to understand what Sir Anthony Hooper had in mind, if Andy Parsons had made that point to me, and if that's what had been passed on to him, then I would have given the advice, of course. It is a lesser offence, and it's one to... And anybody in any environment will often plead guilty or offer a plea of guilt to what they perceive to be a lesser offence. I would have said it plainly. Of course I know that to be the case. I've been in practice for over 40 years. But this was not what I was being asked to do.
Let's look at tab B31, poll 0012577. And we look at page 2, please. At the foot of the page, email from you to Andrew Parsons in the run-up to giving this advice. Third paragraph. In the meantime, one question I have for you is I'd like some expansion, if you can get it, of precisely what Tony Hooper said. The equality of offences is not actually a criminal legal concept, although I understand what this is really all about. What did you mean when you said, I understand what this is really all about?
It was all about a letter. It was all about a letter which had been sent by post office on the advice of Cartwright King to Second Sight, about which Tony Hooper had issues. That's what it was all about.
Aren't you saying there that it's not the technical issue of the maximum sentence of imprisonment or whether they contain both offences, a requirement to prove dishonesty? I understand what this is really all about, meaning sub-postmasters being pressurised into pleading guilty to a lesser offence, and lesser in that context.
No, because you need to read the next sentence.
What I'd like to know is what Tony did say, how he expressed himself, etc. And then if we go, please, to the reply. Page 1, please. Foot of the page. Brian, Tony's comments were, I don't know where you, post office, are getting your legal advice from, but it's wrong. False accounting is a lesser offence than theft. That's what you concentrated on, didn't you?
That's exactly what I did concentrate on, because that's what I thought I was being asked. It was all about, if you go back to the advice, it was all about Cartwright King, and you didn't take me to this actually, Mr. Beale, when we went through my advice, but it's paragraph 6 and then paragraph 7 of the advice. That's what this was all about. Paragraph 6 in its advice.
Hold on.
Sorry.
Mr. Altman,
It's POL.
it's all right, I can give the reference.
All right.
Poll 406588. Second page, foot of. I think you wanted to read paragraph 6.
Yes. In its advice, CK had said that SS's views were inexpert and wrong. On this particular topic, they said, the suggestion that the offence of false accounting is a less serious offence than that of theft. This suggestion has appeared in a number of contexts, most commonly where an applicant has pleaded guilty to the former offence so as to avoid the more serious charge of theft, or has pleaded guilty to the lesser offence of false accounting. And then please to the next bullet point.
Over the page.
In fact, both offences are equal in law, both are offences of dishonesty, both carry the same maximum sentence, 7 years imprisonment. And then paragraph 7, this was used as the basis for a letter that was sent to Second Sight, which included the statement, the suggestion that the offence of false accounting is a less serious offence than that of theft is incorrect. Both offences are equal in law, both are offences of dishonesty, and both carry the same maximum sentence. That's what I was addressing.
Just look at paragraph 8, please.
Yes, it's defensive.
Scroll down, please. Bullet points 1, 2, and 3 focus on the statement.
Yep.
Bullet point 4 asks you whether, in your view, it's fair to characterise these offences as being equal against whatever yardstick you think is most appropriate.
Yeah. Well, I'm afraid if Mr. Beale, with respect, you're saying that that was some Delphic suggestion that I should be looking at the points you're making, then it passed me by. I was looking at the defensibility or otherwise of that letter.
So you thought your task was just to look at the very narrow issue of defensibility?
I did, I'm afraid. I did.
Can we move to a separate topic then, please, Mr. Altman, the legal advice that you gave in relation to disclosure? That can come down from the screen, thank you. Beginning by looking at poll 0012-3003. And if we just scroll down, please. Yes, sorry, just scroll back up, please. It's that sentence, or that paragraph 3 from the bottom, beginning Brian Altman KC's first review has now been received. If we just go to the top of the page, please, to get the context. It's not a chain you're copied in on. It's dated October the 21st, 2013, from Andrew Parsons to a range of lawyers and Belinda Crowe. Back down to where we were then, please. Brian Altman's first review has now been received. We've seen that. The first review looked into Post Office's compliance with its prosecution duties in the light of Second Sight's finding. In particular, it considered the Post Office's legal duty to ensure that the Post Office's findings were fully disclosed.
Second Sight's findings?
Yes, fully disclosed to any person who's currently being or has previously been prosecuted by the Post Office. You concluded that the Post Office is complying with its duties and that the approach adopted by the prosecution team was fundamentally sound. This report gives the Post Office good grounds to resist any formal external review of its historic prosecutions, i.e. by the CCRC. Had you in fact advised that your advice or report or review gave the Post Office good grounds to resist any formal external review of its historic prosecutions?
No.
Was there discussion with you after the production of your review that was how the Post Office was going to treat it, that it gave good grounds to resist any review by the CCRC?
No, no, absolutely not. Not least because this email, as you just pointed out, is dated the 21st of October. We've looked at my work log, and I think the last conference I had was the 4th of October.
Was that an accurate statement of the import of your general review advice?
No.
Was that ever discussed with you, that the review was viewed by the Post Office as a weapon, a shield or a sword to resist any oversight or investigation by the CCRC?
No.
And you didn't see it that way?
I certainly didn't see it that way, and I never saw this.
Can we move forwards, please, to February 2014, poll 302-1750. And can we start on page 3, please? On page 3, we should see a series of questions to you of the 27th of February 14 from Andrew Parsons, the then senior associate at Bond Dickinson. He attaches a report in Mrs. Brewer's case, and at the end of the report, Second Sight draw the following conclusion: that whilst we've not been able to establish a direct causal link between communication line problems and the losses reported, we believe that communication line problems did play some part in these losses. Post Office would be grateful for your thoughts on whether this type of comment is of a type that would be disclosable in other past or future criminal cases. Appreciate this is a broad, very broad hypothetical question, and that disclosures need to be considered on a case-by-case basis. We're looking for a steer on whether this type of general unevidence view could ever be over the disclosure threshold. And then if we look at your reply on page 1, scroll up please. Sorry, page 2, scroll up. Thank you. You say, dear Andy, in principle the comment found in 5.1 would, I'm afraid, prima facie be disclosable in any case involving assertions by a defendant that there was some causal link between communication line.
It says casual, it should have been causal.
Yes. Yeah. And reported losses. The fact that Second Sight's view is unevidence would not alter its potential disclosability as such. And then if we go to the bottom of the page, please. You say the best result for now, last paragraph, would be a concession from Second Sight, that this is a conclusion that's specific to this case only and does not apply across the board, unlike, for example, their conclusions in their 8th of July report. Whether Second Sight might be prepared to concede that remains to be seen. Then over the page, were they not to soften their stance and stand by their conclusion, then we may have a problem. You might then have to think of whether there's any other expert Post Office might instruct who could undermine Second Sight's opinion on this. How realistic in practice this is, and politically, only you will know. And then page 1, please. Foot of the page, please. Mr. Parsons, you're not included on this, distributes your advice. Please see below from Brian Altman, read the comms issue in Second Sight's report. Brian's view is the Second Sight statement is probably disclosable to other prosecuted or convicted sub-postmaster in a similar situation. My view is we're unlikely to make Second Sight change their opinion. Next paragraph, that's not to say Post Office should not challenge Second Sight's conclusion. We should be getting Fujitsu's view and assuming it's strongly supportive, giving it to Second Sight. Fujitsu's analysis can be deployed at mediation and may, subject to Brian's further thoughts, prevent the need for disclosure, mitigate the impact of the Second Sight report in criminal proceedings. When you gave your advice, you began by saying, I'm afraid that this is disclosable. Why were you afraid?
It's just a term that I use.
Were you softening your response to the Post Office by using that phrase?
Softening my response?
Yes, by saying, look, I'm on your side, but I'm afraid I've got to give you some unpalatable advice.
I don't think so. It is, I'm afraid, a term I use an awful lot, and I just used it there. I mean, I'm very colloquial in the way I write, and I suspect that's all it is.
You came up with ways in which the Post Office might be able not to disclose this information to other convicted defendants.
No, I don't think that's fair, actually, Mr. Beer. What I was saying was, before disclosure in cases that may arise, that's the second paragraph, that you should, as it were, hammer this out with Second Sight and find out if it's an expert rather than an inexpert opinion, and see what those discussions bring. That's all I was saying. I did not soften my approach to that, and I did not say that this should not be disclosed. I said before disclosure in respect of any cases that may arise. So in other words, I had already given the advice that it was prima facie disclosable, but that a Post Office were entitled to know what the issue was, whether it was a matter of expertise, and whether the expertise suggested by Second Sight was expert or inexpert. That's all I was saying.
You said the best result for now would be a concession.
Yes.
This is case specific.
Yes.
Can we move on then, please? Seventh topic, Mr. Clark's advice of the 2nd of August, 2013. Can we look, please, at that to remind ourselves of it? Poll 406799. I'm not going to go to the last page because it will take too long, but we know this is dated the 2nd
of August, yeah.
And this was sent on to you, wasn't it?
I'm sure I saw it, yes.
And can we look, please, at page 2, please? At paragraph 5, to see the information on which Mr. Clark was basing his advice.
Yep.
After the call on the 31st, the following information was relayed to him. One, the minutes of a previous conference call had been typed and emailed to a number of people. An instruction was then given that those emails and minutes should be and have been destroyed. The word shredded was conveyed to him. Handwritten minutes were not to be typed and should be forwarded to the Post Office head of security. Advice had been given to the Post Office, which he relays verbatim as, quote, if it's not minuted, it's not in the public domain and therefore not disclosable. If it's produced, it's available for disclosure. If not minuted, then technically it's not. And then Roman 4, please. Sorry, we go up. Thank you. Some at the Post Office do not wish to minute the weekly conference calls. Can we look, please, at poll 406803, which is your general review? And look at page 36, please. And paragraph 111 at the foot of the page. Under other initiatives, you say, I've been provided with an advice written by Simon Clarke, dated the 2nd of August. That's what we've just been looking at, in which he advised on the question of disclosure and post office's duty to record and retain material. In it, he confirmed advice he'd given post office at a meeting at head office on the 3rd of July that there ought to be a single central hub, the function of which was to act as the primary repository for all Horizon issues. The hub would collate from all sources into one location all Horizon-related defects, bugs, complaints, queries, and Fujitsu remedies, thereby providing a future expert witness and those charged with disclosure difficulties with recourse to a single information point where all Horizon issues could be identified and considered. The rationale behind it is to put in place a mechanism to protect the post office from future such issues. In the result, a weekly Wednesday conference call meeting has been established. To meet the requirement, attendees are expected to bring all Horizon-related issues to the meeting and minutes are kept. However, early teething and, in inverted commas, cultural problems arose as highlighted in Simon Clarke's 2nd of August advice, and indeed to me in Harry Bowyer's response to my interim review. You refer there to what Mr. Clarke had described about an instruction to destroy or shred minutes as an early teething or a cultural problem. Is that how you saw it, a teething issue?
I'm not sure necessarily the teething applies to that part of that advice, but the word cultural, you'll see, is in inverted commas. And I think that that refers back to the conference I had on the 9th of September 2013, where you will see it referred to as cultural.
Yes, Susan Crichton said that there had been some cultural problems.
No, I think it was Simon Clarke, actually.
Okay.
Not Susan Crichton, because there's a he that comes afterwards. So it was Simon Clarke who's referring to it. And he also said in that September conference that it had been overcome. And so...
what were the teething problems you were referring to then?
I can't remember. But the cultural problems were certainly, I think, was it John Scott?
The head of security?
Yeah, head of security, who had come up with some ridiculous suggestion, as you've just read out to me, and reminded me of in the 2nd of August advice. I don't know what conversation we had about it during the 2nd of September conference. I'm sure we did, but I had been assured that that had been overcome. I think that's the word that's used, and I moved on.
So you're saying that the teething and cultural problems are referring to something other than the destruction or shredding of minutes?
No, I think the cultural problems refers to the allegation or the idea that Scott had that minutes should be destroyed. I don't know if early teething refers to the same thing or something different. I think
Hold on, just if you look at that sentence has footnote 36 against it. Can you see?
Yeah. I can't see the footnote at the moment.
Yes,
it
if
says
you go
paragraph
down
five,
to
paragraph 5.
Paragraph 5.
Yeah,
exactly. Which is the paragraph I read to you.
Well, maybe I did refer to it in that way, but that was not to be dismissive of it. It was clear to me, and bearing in mind the date of this is the 15th of October, I'd been told 5 weeks earlier that the problem had been overcome, and I may also have understood by them then that in fact nothing had been destroyed or nothing had been shredded, despite the content of paragraph 5 of Simon Clarke's 2nd of August advice. And that's why I didn't deal with it at any length here.
Was the suggestion of the shredding of evidence made by the head of Post Office Limited Security, head of security, where that evidence related to bugs, errors and defects in Horizon, a teething problem?
I'm sorry, can you take me back to paragraph 5 of Simon Clarke's advice so I can just see that again?
Exactly. Poll 406799. And over the page. And it's paragraph 5.
Sorry, where does it say bugs, errors and defects?
That's what I'm asking.
Yeah. No, I mean, this all dealt with, this all related to the Wednesday Hub meeting.
The purpose of which was to
collate issues.
About?
Yes, of course, I get what you're saying. But I had understood all this time later that it was a proposition put forward by John Scott, which had, and it had been dealt with swiftly. And he'd been told in no uncertain terms that that would not happen. I also understood that that had not happened, and it had been overcome. Maybe it's an unfortunate choice of a word, but I didn't mean to dismiss it, as I said already.
You would agree that the word a teething problem, when the head of security is suggesting that evidence should be shredded, is something a little more than teething, isn't it?
I accept that.
Were you made aware, that document can come down, thank you, of any investigation that had been conducted by Post Office into the allegation made against Mr. Scott?
I understood, as I've just said, that the issue had been overcome, so I assumed there had been and he'd been spoken to.
What did you understand had happened in order to overcome the issue?
I can't remember now.
Was the essence of it that the problem had been squared away?
Had been...
Squared away.
I'm not quite sure I understand that term, what that means, squared away.
He had been spoken to. He had apologised. He had said that he wouldn't do it again, or some other form of...
I assume he'd been given words of advice that this is not what happens and it won't happen in the future. But I can't remember. I'm sure there may have been a discussion about it, but I can't remember what was done about it. But as I keep on saying, I knew by the 9th of September whatever had happened and whatever he had said had been overcome.
Did you give any consideration around October 2013 to the issue of whether an instruction by the head of security to destroy or shred recorded information concerning Horizon issues failed to be disclosed?
No, I didn't.
Can we turn to my eighth topic then, please? Legal advice in relation to the CCRC. Can we start, please, by looking at poll 304-0046? An email to you of the 23rd of October 2013 from Mr. Matthews. Subject, CCRC draft letter. As mentioned at yesterday's meeting with, with Chris Oyard, I attach a proposed letter to the CCRC in the light of the fact that you've now completed your review of past and current prosecutions. Leaving aside the fact I've drafted it to be sent by Susan, please can you review and amend it? I'm not precious about my drafting. And can we look at the attachment, please? Poll 304-0047. It's a one-page letter to the CCRC. Second paragraph, I'm now in a position to confirm that Brian Altman, Queen's Counsel, has completed his review of the Post Office's strategy and process for reviewing past and current prosecutions, given the findings of the Second Sight interim report. I'm now in a position to give you an update. As you'd expect, Mr. Altman's review has been thorough, leading to a detailed report. I'm pleased to confirm that overall his view is that the review is fundamentally sound and he's not detected any systemic or fundamental flaws in the review process or in the evidence arising from it. He has, however, highlighted that because the review is a continuing process, and the Post Office has a continuing duty of disclosure. Both Post Office and the external firm of solicitors must be prepared to keep under review and reconsider past cases and disclosure decisions. To give you detail, the process involves reviewing all cases going back to the 1st of January 2010, this being the earliest date on which Horizon Online was migrated into all Post Office branches, and is a start date which Mr. Altman, Queen Counsel, considers to be logical, proportionate and practicable in the light of the known circumstances. The scheme involves the Post Office's solicitors identifying every case within the above-mentioned review period in which the primary or main evidence against the defendant was based on Horizon data. This is done by a SIFT review process. Once a case is identified, senior in-house prosecutors at the solicitors carry out a full case review to determine the question, quote, had the Post Office been possessed of the material contained within the second sight interim report during the currency of any particular prosecution, should or would Post Office have been required to disclose some or all of that material to the defence? And then some statistics are to be set out. Would you agree that the description of your review is very much put at its highest there and lacks all of the caveats which you yourself placed on the Post Office review of its continuing disclosure duties? Well,
it doesn't set them all out, I agree with that. And it does tend to put it at its highest, or at least is an attempt at a summary.
Of course, there's no mention about the concern over the integrity of Mr. Jenkins' evidence.
No, I can speculate why, but I suspect because Gavin felt that this was a letter that was going to the CCRC about historic cases, but I also, in other words, that Gareth Jenkins' taint going forwards, that he would not be used, was not in this letter, but I take the point, if by it you mean, it should also have referred to that fact.
This was the occasion, this might be the 6th occasion I've asked you about it, in which that very issue ought to have been mentioned.
Yep, I agree.
And there's no reference there to the Helen Rose report either, is there?
Well, I'll take it from you. There is a reference to the second sight interim report, but not to that, no.
Do you know why that is?
I have no idea.
Was the impression ever conveyed to you that in relation to the Helen Rose report, from the Post Office's perspective, the least said is the soonest mended?
No.
So can we take our afternoon break there, please, until 3 o'clock?
Yes, of course.
Thank you very much, sir. Afternoon, sir. Can we continue, Mr. Altman, by looking at the disclosure to the CCRC issue, which is my 8th and last topic? Can we turn to 2014 and look at poll 00124350? This is a letter dated the 5th of June 2014 to the CCRC. If we go over the page, please. We can see it signed off by Chris Oyard. And then if we go up the page to page 1, please. He says to the CCRC, in the first paragraph, some apologies over the lack of an update. Second paragraph, I confirm that Brian Altman KC completed his review of the Post Office's strategy and process for reviewing past and current prosecutions, given the findings of the second site interim report, to which Susan Crichton referred in her letter to you dated the 26th of July 2013. That's the draft of which we've just looked at. As you'd expect, Mr. Altman's review was thorough, leading to a detailed report. I'm pleased to confirm that overall his view was that the review was fundamentally sound and he did not detect any systemic or significant flaws in the review process or in the evidence arising from it. He did, however, highlight that because the Post Office has a continuing duty of disclosure, both the Post Office and the external firm of solicitors with vast experience of managing and prosecuting these cases must remain prepared to keep under review and reconsider past case reviews and disclosure decisions. To give you some detail, the process involved reviewing all cases going back to the 1st of January 2010, etc. Essentially, the scheme involved Post Office solicitors identifying every case within the above-mentioned review period in which the primary or main evidence against the defendant was based on Horizon data, and also included those cases involving suggested problems with Horizon training or support. This was done by a rigorous SIFT review process, and then an escalation to senior counsel. Then over the page, please. This involves Post Office's external solicitors carrying out a SIFT of 308 cases, a second SIFT of 229 cases, a full review of 53, in which disclosure was advised in 26, and discontinuance of 4 cases. I can confirm that since the publication of the second site interim report, and despite the Post Office's thorough review, it hasn't received any application for permission to appeal. Were you aware that the Post Office intended to pray in aid your position with the CCRC when it was writing to them like this?
When you say my position, by which you mean?
I.e. the conclusions of your general review.
I don't know what I knew. I can't say now, at this distance in time, whether I saw this letter at the time or not.
That was what I was going to ask. Were you given the opportunity to input into this, to the letter that was eventually sent on the 5th of June 2014?
I really can't say one way or the other.
And so you can't help us whether the description of your conclusions here, which again lack some of the caveats that we've seen in your general review, was something that you had the opportunity to point out?
I can't, but not to be unkind to Mr. Oyard, if you look at the final paragraph, I appreciate the above is a short précis of a very extensive procedure, and should you have any further questions, don't hesitate to come. So, I mean, he left open to the CCRC to come back with further questions, I suppose, is all that can be said.
And so if we go to poll 0015-8047, sorry, poll 0015-0847, thank you. This is the CCRC's letter of the 14th of January, and if we scroll down, it's a requirement to produce materials. I write in relation to ongoing correspondence. Your most recent letter was dated the 5th of July. That's what we've just read.
5th of June.
5th of June, I'm so sorry. We've just read. Then there's some standard text. it's considering the situation regarding the Horizon system and the associated criminal proceedings. The Commission requires you to identify all documents and materials in your possession relating to this matter and to produce them. Specifically, the Commission requests a copy of Brian Altman KC's report. Yes? And it encloses a notice under Section 17 of the CAA 95 requiring the Post Office to do this. Do you remember this development?
I'm sure I must have done.
Do you remember there was a conference in Chambers with you at the end of January 2015 to discuss the CCRC's request for a copy of your general review?
Yes, I'm fairly confident that must have happened.
Can we look, please, at poll 0015-1181? This is the reply to that letter.
Yeah.
And seems a chase call on the 27th. The Post Office has had the opportunity to consider fully the letter and then scroll down. The author notes that the Commission is now considering, this is Jane McLeod, incidentally, the author of this letter, the then General Counsel. The Commission is now considering the situation and notes that the letter and notice specifically requests a copy of Brian Altman KC's report. Background. We trust you'll appreciate that the request you make is with respect wide and in the most general of terms, notwithstanding the specific request for Brian Altman KC's report. I've reviewed the previous correspondence. I summarise that correspondence as follows, and then she summarises some correspondence. That page, and if we go over the page, please. And then scroll down. And then under Poll's position. Having considered the position more fully against this background, I'm unfortunately currently unable to see how the request you make fits within the guidance of paragraphs 4 to 6 of the Commission's formal memorandum, the Commission's power to obtain material from public bodies under Section 17 of the Act. This is especially so given that Mr. Altman's report does not address individual cases, but rather the Post Office's strategy for reviewing past and current prosecutions generally. The Post Office continues to assert that LPP attaches to Mr. Altman's report whilst remaining aware of its duty under Section 17. Further, the position on individual cases remains that in respect of the cases which are prosecuted, it has not been made aware since the publication of the second sight report of any applications having been made for leave to, over the page, appeal. And then the rest of it concerns, there's a sentence which says the Post Office nonetheless wishes to emphasise that it wants to and will work with the Commission. Was it the conclusion of the conference that you had at the end of January that the Post Office should maintain or assert privilege in respect of your general review?
I can't remember what happened in the course of that conference, but undoubtedly the general review was legally privileged, but of course that didn't disentitle the Commission from having sight of it.
No. Did you form a view at the time that the Post Office was, on the one hand, praying in aid your conclusions in correspondence with the Post Office, with the CCRC, and with the other, saying you're not entitled to see those conclusions?
No. I mean, first point, as you've demonstrated, yes. Second point, no. I think all that this letter demonstrates is that the Post Office wanted to be absolutely clear on what basis my review was going to be disclosed to them under the notice.
It doesn't say that, though, does it? It doesn't say we need clarity as to the basis on which...
Oh, I think it does, because if you go back to the previous page at the bottom,
yes,
isn't Jane McLeod talking about the memorandum And if my memory serves me, doesn't the memorandum say that the Commission can only ask for or issue a notice in relation to specific cases rather than a sort of generic notice? I think that's all that was being said here.
So why was the Post Office deploying your advice at all then to the CCRC?
Well, that I can't answer.
I think by 2015, it's right, isn't it, that you had taken a different position to that of Cartwright King on a number of matters?
I would have, or I did.
You did. You had taken a different position to them on a number of matters.
I think so, yes.
Were you aware of whether or not by this time the CCRC had been sent a copy of the Clark advice of July 2013?
Well, we know now that they never were. Your question is more focused as
Yes.
to whether by that time I didn't.
Can we move on, please, to poll 0022 359?
While that's happening, I take it from an earlier answer, Mr. Altman, that despite this letter, shortly thereafter, your report was disclosed to the CCRC.
Yes, 27th of February 2015.
Yeah.
Cross-reference for that, sir, is poll 00151296 for the transcript.
Yeah.
27th of February 15. This is an agenda for a conference with you on the 27th of March 2015 within a project or Operation Sparrow.
Yeah.
You see the heading there.
Yeah.
And you're one of the people to whom this agenda is distributed. Please find below agenda at Finsbury Dials. And then topic 4, approach to / obtaining comfort from pre the 1st of January 2010 prosecutions. Do you remember a conference in which the Post Office wished to obtain comfort in relation to pre 1st of January 2010 prosecutions?
I'm afraid I don't even remember this conference, let alone the agenda, and I can only speculate what point 4 was about. But looking,
Can you help us?
it's a pure speculation. But looking at the date, the 26th of March 2015, bearing in mind that my general review was at the back end of, or the autumn of 2013, we're talking about 18 months on from there. And as far as I know, nothing had changed in terms of information. It may be, I don't know, that the CCRC had asked questions about the cut-off date, the 1st of January, and maybe I was being asked to advise whether it was still appropriate and proportionate and all the rest of it. But to my mind, my knowledge of bugs did not change. In fact, it didn't change until the Horizon Issues trial. So that's my speculation.
Can we look lastly then, please, at what might be a handwritten note of the conference?
All right.
Poll 0015 5545. Poll 0015 5545. Can you see a date in the top right-hand corner
Yep.
of the 27th of March 15, which corresponds with the date set out on that agenda?
Yeah, and whose note is this?
I don't think we know. I mean, it looks similar to some writing that we've seen elsewhere, but I'm not going to turn myself into a handwriting expert.
No.
Can we see 2/3 of the way down the page, please? If you just pan out, please. Yeah, sorry, it's about halfway down the page. Next to CCRC. Can that be highlighted? CCRC sets out statement of reasons, goes to the Court of Appeal. Defendant has own representation. Does that sound like the kind of thing you might have summarised in a conference about the process?
Yes, if I'd been asked about the process to remind them, I would have said this.
And then Court of Appeal, miscarriage because error in conduct, judge made error, new evidence, point of law. I should have said misdirection or ruling against judge made error. So a summary of some of the grounds on which an appeal might be contemplated or even allowed.
Yes.
And then scroll down, please. And then underneath the two horizontal lines, look at horizon, sufficiently reliable question mark. If not, what happened in the particular case? Can you help us as to whether that was you speaking, and if so, what you might have been saying?
Can we just zoom back out so
Yes.
I can see the whole page? Because I'm just questioning. I don't know. If you look at the style of the notes, it begins with arrowed bullet points, and then, as you point out, it's got the two horizontal lines, and then 2 points 1 and 2. So, if we assume that this note is still part of the same conference note of the 27th of March, and if we assume that this was me asking questions, then I think the answer to your question, Mr. Beer, is in the words which are written there.
Okay.
If that makes sense.
If we scroll down a little further, please. At the, up. At the foot of the first page, in capital letters, this is what we've got. It's not everything. Can you help us with any context as to in which that might have been discussed?
Really not. I mean, I wonder if the document handler would kindly zoom out of that again so I can see where it fits on the page, but I'm not even sure if this is not a note to self by the author. By the author.
The passage under the two horizontal lines, look at horizon, sufficiently reliable. Was there any discussion in March 2015 to which you were a party over whether or not the Post Office needed to look again at whether horizon was sufficiently reliable?
Well, just basing myself on the history of my instruction, and obviously you understand that I wasn't working on Post Office every day of every week, far from it. In some years I popped up for individual instruction and then went away for weeks or months, obviously doing other work and other professional commitments. So to answer your question, look at horizon sufficiently reliable, if not what happened in the particular case. I cannot remember after March 2015 until I was asked to do a further review in 2016, other than I'm sure the odd email, possibly a conference, that anything of any substance of that nature was ever put my way.
Thank you. Thank you, Mr. Altman, for answering my questions.
Thank you, Mr. Beer.
So I think there are three core participants who wish to ask questions in the order of Mr. Steen, Ms. Patrick, and then Mr. Henry.
Right. Is approximately 15 minutes each sufficient for them, Mr. Beer?
Absolutely, in particular because Mr. Steen said he would be 10 or 12 minutes.
Right. Well, as you know...
I thought that I was going to be 20. I told Mr. Beer that. I hope you could forgive me if I'm given 15, I might go to 20 because I have a bit of material to put to Mr. Altman.
All right, we'll see how we...
Thank you.
Mr. Steen, let's see how accurate you can be.
Yes, sir, thank you. Mr. Altman, can we just help everybody understand what it means by being Senior Treasury Counsel and First Treasury Counsel? Now, these are terms that we're all used to, those of us that practice in criminal law. Senior Treasury Counsel, your work is engaged with reviewing both that's before and after charge, serious cases that are brought to you. Is that fair?
It can include that work.
Yeah, and it includes advising on such cases that are brought to you so that you can advise in relation to the way that investigations are being conducted, and thereafter investigations continue once an individual is charged. Is that right?
Yes, it can include that.
Yeah, and the work that you've done in that role as Senior Treasury Counsel, then First Senior Treasury Counsel, would have included the most serious of cases that are prosecuted or considered for prosecution within England and Wales. Is that right?
Yes.
Okay. You would have been used to advising on sensitive cases, in other words, cases that carry issues that relate to the different types of police services. Is that also correct?
By which you mean?
Well, sensitive issues that relate to matters that might be covered by PII.
Yes.
Yeah. And you're trusted to consider those cases, those most serious of cases, and give advice as to their progress, yes?
Yes.
All right. So simply put, you're used to dealing with serious, complex, big cases and advising as to what you believe should happen and what would be the right thing to do.
Yes.
Okay. Now, just help us a little bit more. Your position is set out somewhat by some quotes from various, I think, directories that deal with barristers, and some of those quotes are set out on your website. You're described as being one of the greats of the bar. That's one of the quotes. Do you remember that?
Somebody has said that of me in a testimonial on the website. Yes,
that's right. It's on the website for Chambers.
Yep.
It also describes you as being a brilliant operator.
Yes.
That's also on the website for Chambers. Now, let's then turn to how that helps us understand what happened here. Now, the CPS is an organisation, the Crown Prosecution is an organisation that considers and engages in the prosecution of serious cases where people may go to prison. Do you agree?
Yes.
The Post Office at the time that you were first instructed was also an organisation that engaged in the consideration of and prosecution of serious cases whereby individuals may go to prison.
Yep.
Yeah. You've described in the evidence that you've given to Mr. Beer that you didn't address your mind in any of your advices or your review to your ethical position. In other words, you didn't set out that you're following the ethical guidance for advocates within the CPS. You didn't refer to that as an example,
I don't think that was the question I asked. I was asked. I think the question I was asked was whether, because I was acting for a commercial organisation, I was following the same ethics. He did not ask me, as I recall it, whether that was or should have been set out in my general review or any of the advisory work.
Well, I'm sure Mr. Beer would apologise for not asking that direct question, but help us please understand what ethical guide were you following when advising the Post Office?
The same ethics I always employed, Mr. Steen.
Well, as someone that is a prosecutor, that guidance, or as a member of the bar, which?
Well, both.
Right. Now, you use the term Minister of Justice. That's perhaps a short form way of describing the ethical standpoint of a prosecutor. Is that fair?
But it was targeted in this particular case at the Post Office as a private prosecutor.
Right. Does that mean that your advice was any different, do you think, to poll as a private prosecutor versus, say, the CPS if you've been asked to look at similar things?
I don't think so, no.
Right. So you applied the same ethical standards to the work that you did for the Post Office as you would have done for the CPS?
I'd like to think so, yes.
Or did you?
I'd like to think so, Mr. Steen.
Well,
yes.
You've had plenty of time to reflect upon this question. Did you apply the same ethical standards
Yes.
to the work that you carried out for the Post Office?
Yes, Mr. Steen.
As you would have done for the CPS?
Yes, Mr. Steen.
And you applied the same professional standards in other words, professional standards of competence, to the work you did for the Post Office as you would have done for the CPS. Is that also the same?
Yes.
Okay. Now, what's your first duty as a barrister?
Well, there are many core duties as a barrister.
What would you say your first duty is? What, generally speaking, do most barristers say is their first duty?
Integrity, independence, doing the best for your client.
What about duty to the court?
Of course.
Of course. How far do you rank that? Do you say that that's your first duty, or does that come somehow second after a client, as an example?
No.
Right. So where you've got an issue that relates to your duty to the court versus your duty, in this case, to the post office, which goes first?
Well, the duty to the court is the duty that you have when you are an advocate. And I was not an advocate for Post Office until I appeared in the criminal appeals. The duty to the court is not to mislead the court. The duty here, which I'm talking about, and these are other core duties, are integrity, independence, and the other core duties which appear in the BSB handbook.
I thought we'd gone through these questions that related to your ethical approach to matters for the Post Office. And I thought that you'd agreed that you were carrying out this.
You're putting to me, Mr. Steen, what the hierarchy is. The duty to the court can't apply until you're in court, and I wasn't in court on behalf of the Post Office until I appeared in the criminal appeals.
Right. Well, let's think about how that worked out in practice. We've got the position that's set out by Mr. Clark as regards Gareth Jenkins, and that you summarise in your statement at, I think it is paragraph 26, subparagraph 5, page 13 of your statement. I'm happy if it's go on the screen, or I'll deal with it directly. Yep. You're addressing the questions that arise in Mr. Clark's legal advice, and you put it this way. Why Mr. Jenkins had failed to reveal in his witness statements or evidence the bugs or defects he knew about was not a matter for my review. Okay, that's what you say there.
Yes. So
you're saying there, and accepting in evidence, as we understand it, that you were of the view that Mr. Jenkins had failed to set out all he knew about bugs and defects in his statements and in his oral evidence, yes?
Yep.
Right, okay. So you accept that Mr. Jenkins, on the basis of that understanding, had misled the court. Do you agree?
He had, yes.
Yes, okay. Help us understand a little bit, therefore, about what you did about that. Did you, as an example, suggest in your advices that the Post Office really needs to rectify this misleading of a court? Did you do that?
What do you mean by rectify?
Well, go to the court and say, this is what's happened, this is what we believe has occurred, Mr. Jenkins has misled the court. No. Did you advise that?
No, you know I didn't, Mr. Steen.
Right. So we get to the point, is this correct, Mr. Altman, that you knew that had happened, but you decided not to try and rectify the misleading problem? No. Is that correct?
No.
Well, help us understand, Mr. Altman.
Will you let me give an answer, please, Mr. Steen?
I did. You said no. So help us understand what you did about that problem.
The evidence I have given is I did not apply my mind at the time to revealing or disclosing or advising on disclosure of the taint by Gareth Jenkins for the reasons I've given. What you're suggesting is I applied my mind and made positive decisions or negative decisions. I didn't. You won't find a single word unhappily about it in the general review.
You say unhappily because you recognise that obviously something should have been done. Is that fair?
I have conceded and I've accepted on several occasions when Mr. Beer asked me the question that what I should have done is I should have advised consideration of the disclosure of the fact that Gareth Jenkins was tainted, and that his assessment, or the assessment of him as an expert by Cartwright King and me, was disclosable and should have been disclosed in suitable cases.
Mr. Altman, what would you have done if the situation had been that you were working as Senior Treasury Counsel, advising the CPS, and within an investigation that's brought to you, the police officers tell you, look, we've got this expert, we've used him in the past, we're thinking about using him this time, but actually it turns out that we think he's bent. And the reason why we think he's bent is we think he's frankly not told the court the truth in the past. What would you have done in that situation, advising the CPS about that expert?
Well, I mean, with the sort of clarity of the question that you have just posed to me, Mr. Steen, I would have said we can't use him.
Yes.
And what is the CPS doing about past cases?
Yes. And what about perhaps an investigation into that particular expert, that person that has provided that evidence to the court? What would you have said about that, Mr. Altman?
I don't know. I'd need to understand what the specifics were and the actual case.
Well, let's make it simple, Mr. Altman. The same situations you had here arising in a CPS case, you would have said this needs to be looked at with care and investigated. Do you agree?
Well, I would have certainly have gone to the CPS and say, frankly, I would have said, you deal with this. You need to look at what's happened. You need to turn out all the cases he's been involved in. If you're talking about a police investigation or an internal investigation, I'm not entirely sure, but it might have come to the same thing.
But you didn't do that here.
No, I didn't.
Right.
I think we've actually established that many hours ago now. And Mr. Steen,
yes,
your time is running out, so to speak.
I recognise the clock and the sounds are going through. We have recognised that. And you've explained that you're frankly tired of people asking these questions.
No, I haven't said that, Mr. Steen. No, I haven't said that, Mr. Steen. I have made my position perfectly clear every time that Mr. Beer has asked me.
Why didn't you? Do you now, after all of this time, have any reason that you can give why someone who appears on the face of it to have straight misled the court, you did nothing about it? In other words, you allowed it to continue. Can you explain it?
No, I didn't allow anything to continue. I'm human like the rest of us, Mr. Steen, probably including you. And I make mistakes, and we all make mistakes. And as I said earlier, I would like to say it was misjudgment. I don't think I made the judgment about it. It passed me by. I don't know why I didn't see it. It's regrettable, and I regret that I didn't.
Was it a failure of duty?
No, absolutely not. Because a failure of duty imports a positive, conscious decision not to do something. My point is, the general review contained 50-odd pages of just about every thought I had, and I record everything. And the fact, actually, when I came to look at this, and I realised that I hadn't said it in recent weeks, I was flabbergasted, and I can't understand putting myself back all of those years why I didn't, but I didn't. And so it was a mistake, it was a genuine mistake, but any inference that anyone chooses to draw that I made a conscious decision not to do it is wrong. And it's also wrong because the CCRC had the general review in February 2015. That's not mitigation, and I'm not making an excuse, but I make mistakes like everybody else. I'm not perfect, and I did my best with the resources I had here. I didn't have prosecuting authority like the CPS or the SFO around me to help me in the decision-making.
So you say a failure of duty only applies if you make a positive decision to either look at something and then not consider it.
No,
what about just simply failing to do something, Mr. Altman?
No, I think, well, no, you can fail in your duty, but the duty sometimes has to have a motivation or intention behind it, and I think you're imputing that to me. That's my take on your questions to me, and there was none.
Okay, let's move on, as I've got very little time left indeed, if any at all. You've directed yourself to the question, which is you've learnt matters that arose in the High Court, because you were asked to review the High Court decisions, and you learnt then that the Post Office had within the organisation awareness of, as an example, the mismatch bug in 2010. That's one of the things you learned, okay? You then went on to prosecute matters in the Court of Appeal.
I responded to matters in the Court of Appeal.
You then went on to respond to matters in the Court of Appeal on behalf of the Post Office. Do you agree?
Yes.
Okay. So by the time it got to the Court of Appeal stage, you must have said to yourself, well, the Post Office appears to have known certain information, mismatch bug, remote access, that they didn't tell you about when you conducted your review. Do you agree?
That follows.
Right, okay. Did you address your mind to the fact that therefore you were also someone that had been misled by the Post Office, that they had failed in disclosing material to you? Did you turn your mind to that?
I think it was implicit in the fact that everything I read in the Horizon Issues judgment suggested that there were bugs, errors and defects which had never been brought to my attention.
Were you not a witness, Mr. Altman, to
No,
those?
no.
Can I finish the question?
Yeah, you finish.
Were you not therefore a witness based upon what you've just agreed?
No.
So those failures of disclosure to you, in other words, someone that could testify to the fact that here is the Post Office instructing senior Treasury Counsel, ex-senior Treasury Counsel, on serious matters requiring serious reviews, and yet they hadn't told you the truth.
I was never a witness. I was never likely to be a witness for the simple reason, Mr. Steen, that the Court of Appeal was looking at abuse of process at the time of the prosecutions and the convictions and not afterwards.
There was a decision made in relation to the response, as you put it, by the Post Office to those appeals, that a consideration was given to essentially looking at the evidence that related to the period up until 2013, the end of the prosecutions conducted by Pol.
That's not right. That's not right.
Okay, will you correct me then?
You're ignoring the disclosure management document, which is dated August 2020, in which it was made perfectly clear in paragraph 5 what the relevant period was. That was updated by the addendum disclosure management document of the 11th of January 2021, paragraphs 19 through to 21, which describe in absolute detail why the relevant period was picked. And as you know, Mr. Steen, because you were involved in the appeals, the Court of Appeal agreed.
The decision-making in relation to taking up to 2013 as being generally the period of time to consider for disclosure, not entirely, but generally. That excluded all of the work that you did that followed 2013, the reviews you did of the High Court, what you did or didn't know potentially that was provided to the High Court, the other advice and work that you had done for the Post Office, didn't it?
Well, if you're saying that that was a deliberate decision, you're absolutely wrong.
I'm asking whether it excluded it, and then I'm going to ask you whether that was considered by you as being a defect in looking at the time period.
I think the answer to that question would fall to be answered by reference to decisions made post-February 2020. The significance of the date of February 2020 is that the
But I've
date...
got it, Mr.
I understand.
It relates to the extent of the waiver of privilege, doesn't it?
I know, that's why I was asking questions about whether Mr. Altman considered rather than whether he discussed it with his team.
Anyway, I think on any view of it, you've had a very generous 15 minutes, Mr. Steen.
Thank you,
So
sir.
I think we're going to call it a day at that point.
Yes, sir.
Thank you, sir.
Thank you. Ms. Patrick, you have until 5 to 4, which gives you a very generous 15 minutes.
Thank you, sir. Mr. Altman, my name's Angela Patrick. I act with Hudgell Solicitors and Mr. Maloney KC for a number of sub-postmasters who were convicted and have since had their convictions quashed. I'd like to look at one issue, and you've referred to advices after the general review. I would look at the 2016 post-SWIFT review advice, and I really only want to look at, as one example, the review of Mrs. Hamilton's case. You can see Mrs. Hamilton sits next to me today. So if we could turn to Paul 3022854, please. And we can see there on page 1, it's headed Review of Post Office Limited Criminal Prosecutions. Just to start with, this was not a full independent review of all criminal prosecutions, was it?
Oh, no. These were cases selected for me by Post Office.
And I think I can help further. If we scroll to the bottom of the page at paragraph 3, you can see it yourself now, it's on screen. But just very briefly, the instruction was limited only to the question whether in a limited number of prosecutions you were asked to look at whether Paul had acted properly in charging both false accounting and theft.
Yes, this arose from the earlier SWIFT review.
Yeah, and if we can look very briefly, I'm conscious of time, at page 28, we see your conclusion on Mrs. Hamilton's case file. And we can see there, while it cannot be said the material in this case, well, it cannot be said on the material, I have seen in this case that the count of theft was charged and indicted solely and improperly to influence or encourage guilty pleas to the counts of false accounting. At this stage at which Mrs. Hamilton had indicated she would plead guilty to the false accounting charges, the condition of repayment in return for the dropping of the count of theft, in my view, could lend itself to the possible, unfortunate allegation that what occurred provides evidence of the manipulation by the prosecution of the criminal process by securing the repayment of its losses through the criminal process, in particular by the charging of theft. Sorry, that took a little while to read out, but I thought for the transcript it's important to know where we're starting. If we could look now, sorry, I apologise. If we look now, there are some other explanations earlier in your advice for the basis of your approach. So if we could go to page 27, sorry, page 8, paragraph 27, please. And you'll see there about arguments to resist the allegation that it was improper to charge alternative offences, and you deal with the defendant was able to challenge the sufficiency of the evidence said to underlie the theft charge, and if so advised, to seek its dismissal. Indeed, it was open to the defendant to contest all charges and seek to make a submission of no case to answer, and so on. If so advised, the defendant could, through his advisers, seek disclosure, which might reasonably assist his case. And finally, it's the defendant's decision to plead guilty to a charge, and so on.
Sorry, forgive me, Ms. Patrick, is this in relation to Mrs. Hamilton or just...
This is generally
the general,
yeah. Right.
Yeah, thank you.
I just want to say there, you're emphasising there in paragraph 27 the role of the defence and the ability of the defence to seek disclosure. By this time in 2016, just to be absolutely clear, you had not been asked to look at how the Post Office typically responded to defence requests for disclosure of material relevant to bugs, errors or defects in Horizon.
Generally, no.
Thank you. And did your advice proceed in an assumption that the Post Office had complied with all of its obligations on disclosure in the face of any defence request?
Sorry, can you ask me that again?
Sorry, I think I may be trying to go too quickly. I apologise. Did your advice proceed on the assumption that the Post Office had complied with its obligations on disclosure in the face of defence requests? Essentially, were you assuming that the Post Office had done its job properly when it was asked for disclosure by the defence?
At the time of prosecution, you mean?
Indeed. And at the time in 2016 when you were being asked to look again at some of these cases?
Well, I think I must have been, yeah.
And can you recall whether at that point in 2016 your confidence in being able to take that kind of assumption may have been impacted by what you knew by 2016, including the issues which had led to your original instruction?
Forgive me, ask me that again, please, Ms. Patrick.
Was your confidence in any assumption about what Paul might have done in respect of his disclosure duties impacted by what you knew in 2016, including the issues that led to your original instruction?
This review was not about bugs, errors and defects. This review, as you know, was for a particular purpose. That it was actually led on from what Mr. Beale was asking me about before, second sites.
Indeed, and I think we clarified that at the start.
Yeah, well, the point is that the disclosure decisions in the individual cases I was asked to look at did not cover bugs, errors and defects, but other issues. And therefore I wasn't looking at that. And did it impact on my confidence? I think in terms of what I saw here, and given that I was looking at a particular issue, no.
Thank you. You raised a particular concern about a condition placed on not proceeding with the theft charge. And if we look at page, 27, we can see at 107, you elaborate on that. I apologise, I'm trying to do this as quickly as possible. And again, you say, the effect of the arrangement was that the prosecution was in effect allowing Mrs Hamilton to buy her way out of a charge in which the House lawyer and counsel advised there was sufficiency of evidence. Second, the question might be asked if the prosecution felt the evidence was sufficient. Third, if Mrs Hamilton did have a tenable defence to the count of theft, although I've seen no defence statement providing any defence, and I doubt that a defence statement was ever served, then it might be argued that the suggestion she should repay losses in return for the dropping of the theft count, which was the idea originating with the prosecution, blah, 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 blah. You say, again there, you're emphasising the lack of a tenable defence. We'll come back to that point, but do you recall, did the Post Office take any action on this advice you gave on the conditionality of its approach to the theft charge?
On this review in Mrs Hamilton's case? Is that what you're asking me?
Yes.
I don't know.
Thank you. If we look very briefly, because I am conscious of time, at the specific consideration of Mrs Hamilton's case and the facts therein, if we can scroll up a little to 25, at paras 100 to 101, and at 100, we won't repeat it. It sets out Mrs Hamilton's conviction and the sentence that she was serving and the relevant undertaking to pay back the monies said to be owed to the Post Office. It goes on to say a little about the review, and you say, I agree, absent any tenable explanation from Mrs Hamilton consistent with her not being guilty of theft, there was indirect evidence to support the charge of theft. And you say why, and you say at the bottom there, in her prepared statement, which is the only word she uttered about the audit shortage, she appeared to blame a lack of training and shambolic Post Office systems. However, further investigation of her calls to the Horizon Help Desk, if we can scroll over to the next page, and to the NBSC helpline failed to explain the loss of over £36,000 and, more importantly, the reason why she would need to falsify the declarations to such an extent, and so on. Now, absent any tenable explanation, this seems critical to your conclusions there. And we've seen the reference to the calls. In para 67...
Well, first of all, when I talk about indirect evidence, I think what I was talking about there was circumstantial evidence.
Indeed. I simply want to explore what you had seen at this stage. And we don't need to turn it up. We can if you want to. But at paragraph 67, it reads, insofar as calls to the helpline go...
Sorry, forgive me, which paragraph are we looking
67.
at? That's not up on the screen.
I apologise. 67, please. It's page 18. It says, insofar as calls to the helpline go, the investigator had examined, and you set out what the investigator had examined in respect of the call logs. A number of calls had been reported, but the investigator concluded he could not see, and it quotes, anything that relates to a single or multiple discrepancy which would account for the audit deficit of £36,644.89. And you're saying that the investigator had examined, and I assume you would have seen the investigator's report by Mr. Brander.
I'm sure I must have done because I refer to it in this document.
Yeah. And I think here, looking at what you were actually looking at, you were looking in this advice at what the investigator had seen and what had then passed to the legal team for them to consider the charge. Is that fair?
I think so.
And that was the basis on which you were looking at whether any explanation had been offered by Mrs. Hamilton, tenable or otherwise. Is that fair?
I was looking at all of the evidence, and all of the evidence. When I say all of the evidence, I don't know if I simply had investigators' reports, advices, and that sort of thing. Possibly some of the background information I frankly can't remember after all of this time, but I was looking at all of the evidence.
Now, we won't go through it. We don't have time to go into the detail. We are all familiar with the conclusion of the Court of Appeal Criminal Division in Hamilton. Yeah. Mrs. Hamilton's been a case study in this inquiry. The inquiries held reference to call logs and to statements, including by Andy Dunks of Fujitsu, and to treatment of ARQ, including in a statement by Penelope Thomas, again of Fujitsu. You wouldn't have reviewed the detail of the call logs yourself in 2016?
No, just I was presented with presumably summaries or other such documents which help me write what I wrote.
And you wouldn't have looked at the Fujitsu evidence in the case yourself or any ARQ material?
No.
A full independent investigation of what actually happened in Mrs. Hamilton's case was beyond your instructions on this advice. That's really just not what you were being asked to do by the Post Office at this time, was it?
No, I wasn't. I was being asked to look at one issue which had been raised by Jonathan Swift in the Swift Review.
Would it have been open to you to ask the Post Office to extend your instructions or to advise them that they might want to look more widely at the conduct of investigations?
Well, anything was open, but I was asked to do a specific task which had come out of the chairman's report, which was written by Jonathan Swift and Christopher Knight. So, yes, technically open, but I don't think that it would have occurred to me to have suggested it.
I just want to look at one point in Mr. Brander's report. Could we look at Paul 3044389, please, and page 2. And before it comes up, I'll explain what I want to look at. We're looking at the description of the audit that was conducted at Mrs. Hamilton's branch, very briefly, and I want to look at the bottom of page 2. We see that Mr. Stewart completed a full audit of the cash and stock and identified a deficit of 36,583.12, which is broken down as follows. We don't need to look at the breakdown. At the final paragraph on that page, Mr. Stewart also identified an additional 61.77 pence, shortage on horizon, which couldn't be accounted for, and thus the figure posted to late accounts was, and the figure is then given. In the context of your engagement with the Post Office and the issues that had been raised by Horizon, having read this report, would that information, that an additional sum during the audit, when Mrs. Hamilton wasn't present, had been found that simply couldn't be accounted for, did that give you any pause for concern?
I'm afraid, Ms. Patrick, the reality is when I looked through this, I suspect that didn't register in the way that after all of these years one can look at and confidently say, you know, there's a problem screaming out for examination. As I repeat, I was looking at all of these cases, and not just Mrs. Hamilton's, but I think 7 others, for a particular purpose, and identifying flaws, although looking back after all of these years, clearly significant, was not something that I would have registered.
But just to take pause, given what you knew by the time you were being instructed to provide this advice in 2016, you'd seen the second site report on bugs, you'd seen the Simon Clark advice, the Helen Rose report and its treatment. You'd conducted your own critical analysis of how historic prosecution policies at the Post Office had operated. And in this case, you'd raised your own concern about the approach to conditionality on theft in Mrs. Hamilton's case. Was there no basis at this time to be at least professionally curious as to whether all reasonable lines of inquiry, any tenable exploration, had properly been investigated by the Post Office?
Well, I come back to Ms. Patrick, what I said. You're talking about a figure of 61.77. You're assuming that I read it, I absorbed it, and I diverted my attention, or should have diverted my attention from what I was being asked to do. I'm afraid I didn't.
And one final point. You mentioned that your advice termed your general review, and Mr. Beers dealt with you with that. It was provided to the CCRC eventually. Do you know if this later advice in 2016, which included your view on the conditionality attached to the position on theft. Do you know if that was provided to the CCRC?
I'm fairly confident it wasn't.
Thank you, Mr. Altman. That's all the questions I have.
Perfect timing, Ms. Patrick. Mr. Henry, 4:15 is your cut-off point.
Thank you, sir. Looking back, thinking about the iterative process, the negotiations, the horse trading, arm wrestling, whatever you call it, as to how you had your terms of reference established, and the carefully beveled or chamfered ambit of those terms of reference, do you think that you might have been set up?
By the post office?
Yes.
I mean, that's a very interesting proposition, Mr. Henry. I haven't quite thought about things like that. I have thought, I'll be frank with you, whether the fact I just left TC's room, Treasury Counsel's room, and I just finished my tenure as first senior Treasury Counsel, and looking at an email which I'd never seen before this week, about the different Queen's Counsel at the time people were looking at, whether they took comfort from the position I had been in. I've never thought that I was set up, I have to be frank with you, but it's a thought to wrestle with.
But this, I think, probably, unless I'm making an assumption, after many, many years assiduously acting on behalf of the Crown, how much of this sort of investigations, sort of white-collar work, effectively, had you done?
Around that time, actually, just around that, I think, I mean, I haven't gone back through my diary, Mr. Henry, you'll understand, but I was doing some, but in terms of white-collar, I think I would have done some advisory work around that time, but if you're asking me, had I been prosecuting fraud cases, no.
No. Now, you said this morning, when Mr. Beer was asking you some questions, that you ought to have assessed for disclosure Gareth Jenkins' credibility. His credibility should have been considered for disclosure and disclosed with the benefit of hindsight. And Mr. Beer was asking you specifically through the lens of the SEMA Misra case. And you said at that stage in your evidence, Misra was a slightly different case. The focus at that time was Horizon Online. Her branch was affected between 2005 and 2008, so it was a legacy Horizon issue. When it came to the appeals years later, the landscape was completely different. And then these words, one of the problems was that perhaps taking a naive view, the two new bugs in Horizon Online revealed to Second Sight, I felt could not be material in her case.
Yeah.
I mean, forgive me, but naivety is not an attribute normally associated with former First Senior Treasury Counsel.
And I was meaning it in terms of my understanding of the technicality.
I see.
So, in other words, Mr. Henry, of course, looking back, you're right, and the taint should have been disclosed, certainly to Mrs. Misra, and I've conceded that now probably for the 7th time. But what I mean by naivety is my naivety about the impact of a system like Horizon, whereby if you have two new bugs and Mrs. Misra's branch was legacy Horizon, I did not understand, and nobody put me right, that those bugs could not be referred backwards to the legacy system. That's what I meant by it. And
did you form the same view in respect of the receipts and payments mismatch bug when you became aware of that? That only affected, for example, I think you thought only Horizon Online.
Do you mean, forgive me, I've got a terrible throat. Do you mean the receipts and payments mismatch bug which Second Sight revealed in their interim report? I thought that was just Horizon Online.
I see.
Not least because, if my memory is right, Second Sight say it didn't arise until September 2010.
Well, leave that to one side. You've accepted that you're not perfect, that you're human and you're fallible. Do you accept that when you look back at this now, over a number of years, you made some mistakes in the advice you gave the Post Office?
I've conceded that.
Yes. And that those mistakes, if you had been aware of them at the time, they would have put you in conflict with your own client, wouldn't they?
I don't quite understand the question.
Well, I mean, let's just take two examples to sort of make it concrete. The 2010 cut-off date that you accepted was logical, proportionate, etc., etc. Do you accept now that that was a mistake?
No, I don't. As I said, because Mr. Beer asked me the same question, I don't.
I see. Well, I'll move on to something which you know I'm coming to because it's now the 8th time. The non-disclosure to SEMA Misra of the Clark advice, you do accept that that was a mistake?
Of the advice itself?
Yes, not to disclose the fact that Gareth Jenkins was a tainted witness to Mrs. Misra's
Well, yeah, and forgive me, there are two different things. The Clark advice is a document, if that's what you mean, no. Yeah. The information within it, yes.
Yes, exactly. Right.
Let me understand this. The Clark advice as an advice presumably would be legally privileged, and you wouldn't disclose that as a document, but you should have disclosed the relevant parts of it.
Well, the part which I've been asked about 8 times now, yes.
Yeah, well, and I'm in danger of making it 9, but it's just so that I've got it right. Yeah. It's not the document itself, it's part of the information contained in the document.
Yes.
Yeah. Now, what I'm trying to concentrate on here is that, and I hope that you will forgive me, I have to put a characterization on it, but the advice you were giving to the Post Office, for example, in connection with the CCRC, was engage with them by all means, appear to be helpful, but let them make the running.
I think the relationship with the CCRC is a different one, where the CCRC issues notices. But as I understood it, Post Office were cooperating and were engaging with the CCRC.
I see. Can I just put to you fairly and squarely, what I'm suggesting to you is that, regrettably, as is demonstrated by the monstrous delay before these matters went to appeal, the policy of disclosure was a lack of proactive engagement and candour with the CCRC. What do you say to that?
By Post Office?
Yes.
I know in later years Post Office were keen to carry on talking to the CCRC, but I think there came a point, in fact I know there came a point, when they would have been very happy if CCRC had stopped their interest.
Now, can I just ask you to consider this? You've accepted that you made mistakes, but what I'm going to be suggesting to you is that you were in the position, Mr. Altman, of being somebody who had been constantly backing the wrong horse so far as the strategic and tactical advice you've been giving the Post Office. Do you think that's unfair?
Strategic advice I had been given?
Yes, you've been giving them. Giving them, yeah, backing the wrong horse.
Post Office were my client. Well,
let's go to your note on the Horizon Issues judgment, which is POL 406396. And if we could go, please, to paragraph 4. And this is after the monumental judgment of Mr. Justice Fraser, and you had been, first of all, given sections A to L and then section M, and then you read the technical index. But the monumental judgment of Mr. Justice Fraser on the Horizon Issues judgment, and this is what you say at paragraph 4. In my view, these passages are a good reminder to any convicted claimant, as well as the CCRC, that this judgment has its limitations. The judge did not make any findings about individual convicted cases. He did refer to the Misra case at various points in the judgment, but in none does he analyse the evidence against her or make any particular finding which could advance any appeal in her case. Looking back on that now, Mr. Altman, that's a somewhat curious judgment by you, isn't it?
I was asked by Post Office, and I think it was Herbert Smith at that time, to point out to Post Office and them Post Office's exposure to risk, which is what Post Office always wanted to know. And this was my view of what the Horizon judgment, or the limitations as I understood it at that time, were.
The judge actually quotes Gareth Jenkins' evidence in Mrs. Misra's case, doesn't he?
I don't remember.
Well, he does.
I'm sure you're right. I'm not going to dispute it, Mr. Henry. I just don't remember.
Not to worry. Let's move on to paragraph 13. And you accept that what is Pol's duty if material comes to light after the conclusion of proceedings which might cast doubt on the safety of a conviction, then there's a duty to consider disclosure. This is just another way of saying that if there was any material non-disclosure at trial, Pol has a duty to consider the matter for disclosure. That said, I'm far from sure, in the light of the limitations in the Horizon judgment, that anyone can say presently that any material has come to light which might cast doubt on the safety of any of the convictions without there being a wholesale review of each and every one of them. Do you still stand by that judgment?
At the time, and in fact during the appeals, our argument was, and my view had always been, and I say our, it wasn't just me, it was the whole team, but I obviously take responsibility for it, was that the Court of Appeal would have to review each and every case specifically, yes.
I see. But anyway, there we have it. You've correctly stated the none test there, because obviously that is the none test, isn't it? If material comes to light after the conclusion of proceedings which might cast doubt on the safety of a conviction, then there's a duty to consider disclosure. You correct?
Well, it's part of the none test.
Yes, it is, isn't it? Let's go to a manuscript note which is attributed to Mr. Williams. It's POL 001 55554. And could we just make it a little bit bigger? Do you see that you are recorded to have said that you were perplexed about Mr. Justice Fraser? Can you remember saying something about being perplexed about him?
Well, it doesn't attribute that remark to me, but let's assume it was my remark.
Oh.
I'm sorry to interrupt, but I thought that Mr. Beer said when this document was put to Mr. Altman that we didn't know who the author was.
This was a different document, Sir Wynne.
Different, I'm sorry.
Yeah. It certainly says at the top, conference with BAQC. As I say, it doesn't attribute that remark to me. Maybe I was perplexed, but what the perplexing was, I can't tell you.
It goes on to say whether it gives the CCRC what they want is questionable.
Yeah.
And then it goes down further. If we could just scroll up, please. Little assistance to CCRC beyond our understanding about Horizon.
And above that, if I may, no, and this is attributable to me, no findings, individual complainants affected by a bug or remote access on a branch account, mere potential, neither here nor there. So the way I read the judgment, and of course this advice or this view didn't age very well, because we all know that CCRC took a very global approach to the issues, as did the Court of Appeal, and I'm certainly not criticising. I understand precisely why. But at that time and later, certainly my view was, based on my understanding of this kind of situation, that the Court of Appeal would have to look at each individual case.
Yes.
Case specifically.
But you accept that you backed the wrong horse?
Well, I don't like that term, Mr. Henry, because the suggestion to me is I should have given different advice, or given advice which I felt was otherwise, and I didn't. This is the advice I gave. So if that's what you mean by a horse, you may think it's the wrong horse. At the time, I felt it was the right horse.
All right. Well, let's just go to POL 00337 and this is a note of a conference, or forgive me, consultation with you on the 20th of December 2019. And
I think I may have seen this in the further bundle I got this week.
Yes.
I don't think I'd seen it before then. Do you know whose note it is?
I'm afraid not, but it is on the system attributed to a consultation with you on the 20th of December.
And is it dated?
Forgive me?
Is this note dated?
I'm not sure if the note itself is dated, but you are definitely referenced in it, Mr. Altman.
Okay.
Could we scroll up, please? And we can see Horizon Issues judgment has its limitations, etc., etc. Next paragraph, failed to see how anyone can make arguments on the basis of his convictions. Should that be conclusions?
I didn't write the notes, but
Of course.
I assume that ought to be the word, Mr. Henry. Yeah.
Next paragraph, CCRC under-resourced and overworked. CCRC has to do the work with PO cooperation, cannot make reference to the Court of Appeal unless they come to the view there is a reasonable prospect of success, etc., etc.
I doubt I'd have said reasonable, because I think the test is real.
Yes. Go to the next page, please. And we've got, have we not, at the bottom of that page, under your view, BAQC view, last sentence, CCRC may never make a reference. Is that advice that you think you might have said on the 20th of December 2019?
Well, do you mind if we look at the paragraph under my initials to see what the advice was, which was to engage with them to show that we, in other words, Post Office, are being responsible. And this is, I mean, you say it's a note of the conference for the reasons you give, and the we may be the author of this document who was within Post Office, but be that as it may, we're being responsible, and that we, with, as it reads, to cooperate, and that we are willing to cooperate, but seek their guidance, want to avoid any missteps, might at the same time get an idea where they are, where they're not, would avoid the risk of Post Office being criticised for being self-serving, forgive me, or uncooperative.
Of course.
If didn't engage, and we'd done X when they wanted us to do Y, back to the drawing board, an auditable, sensible attitude to take shows Post Office in good light. Anything that we do as the stamp of approval can't go own way, would, in my view, be plain daft. CCRC may never make a reference. I mean, some of that could have been my advice. Some of it might have been the author of this note's takeout from my advice. And Mr. Henry, it's perfectly possible that I could have said, in the end, they may never make a reference.
Now, Mr. Altman, I have got very, very little time, and I've got two more topics to put to you with the Chairman's permission. So, if you will forgive me, if we don't put it up on the screen unless you specifically wish to, but you were shown a document during the lunch hour,
yeah.
And I will give the reference in case you would like to see it put up on the screen. It's 003333839, and you're reported to have said in a note that the only basis upon which you would advise disclosing the draft Deloitte report.
Which draft? What was the date of this conference, please?
Should we go to the date of the conference please?
I think it was November 2016.
November 2016, thank you. The only basis on which you would advise disclosing the draft Deloitte report outside the constraints of Section 17, notice, is if it would help the Post Office. Now, obviously that was advice that is attributed to you. Do you think that you might have said that?
I'm not sure of the context, but I did read very quickly the notes which you asked me to look at over the lunch hour, and I think in the end, after a round-table discussion when Roderick Williams turned up, I think the advice was that the Deloitte report, whatever it was, should go to the CCRC with a request for a notice for it.
Was it not that, in fact, they should make a Section 17 request, which would be covered, of course, by Section 25?
Yeah, inevitably at that time, yeah.
Well, I'm going to move on. Very last subject, one you're familiar with. You were asked why there wasn't an investigation into how Mr. Jenkins came to give misleading evidence that Mr. Clark said was fatally undermining of his credibility. And you responded, I was giving advice to the Post Office. I thought the advice I was giving was on the impact of that failure on the prosecutions and the convictions, and not the reason why he had failed to do it. Can you see the connection between the failure to investigate that issue and the validity or defensibility of the 2010 cut-off?
Ask me that again, please, Mr. Henry.
Well, ought there not to have been an investigation, Mr. Altman, into the extent of the bugs that Mr. Jenkins might have been aware of? Because that would be, of course, highly material to whether the 2010 cut-off was a defendable position.
With hindsight, the answer is an obvious yes. With the position I was in at the time and the realization that Gareth Jenkins had revealed himself those bugs to Second Sight, I suppose I had come to the view that if he had revealed those bugs to Second Sight, he would have revealed others that he knew.
So that was an assumption?
It was obviously a wrong assumption, but yes, it was an assumption, I suspect.
Thank you very much, Mr. Henry. You had your 2 extra points and made them. So I think that brings this evidence session to an end, does it not, Mr. Beer?
Yes, it does. Excuse me. Yes, it does, sir.
Right. Thank you, Mr. Altman, for your witness statement and for answering a great many detailed questions during the course of today. I'm grateful to you. So we'll continue tomorrow with the evidence of Mr. Clark.
That's right, sir. 9:45.
Right. Thank you very much.
Thank you, sir.
It is a world seemingly familiar, yet filled with fresh revelations. A young planet called Earth. Sony 4K captures nuances that escape the naked eye to show you reality with colors and clarity that awaken all your senses and resonate deep inside. If you think you've seen it all, prepare to be amazed. This is Sony 4K. This is a new dawn. Wake up. Open your eyes. This is Sony 4K. Beyond 4 times the resolution of 1920 by 1080, it will take you to another world. It is a world seemingly familiar, yet filled with fresh revelations. A young planet called Earth. Sony 4K captures nuances that escape the naked eye to show you reality with colors and clarity that awaken all your senses and resonate deep inside. If you think you've seen it all, prepare to be amazed. This is Sony 4K. This is a new dawn. Wake up. Open your eyes. This is Sony 4K. Beyond 4 times the resolution of 1920 by 1080, it will take you to another world. It is a world seemingly familiar, yet filled with fresh revelations. A young planet called Earth. Sony 4K captures nuances that escape the naked eye to show you reality with colors and clarity that awaken all your senses and resonate deep inside. If you think you've seen it all, prepare to be amazed. This is Sony 4K. This is a new dawn. Wake up. Open your eyes. This is Sony 4K. Beyond 4 times the resolution of 1920 by 1080, it will take you to another world. It is a world seemingly familiar, yet filled with fresh revelations. A young planet called Earth. Sony 4K captures nuances that escape the naked eye to show you reality with colors and clarity that awaken all your senses and resonate deep inside. If you think you've seen it all, prepare to be amazed. This is Sony 4K. This is a new dawn. Wake up. Open your eyes. This is Sony 4K. Beyond 4 times the resolution of 1920 by 1080, it will take you to another world. It is a world seemingly familiar, yet filled with fresh revelations. A young planet called Earth. Sony 4K captures nuances that escape the naked eye to show you reality with colors and clarity that awaken all your senses and resonate deep inside. If you think you've seen it all, prepare to be amazed. This is Sony 4K. This is a new dawn. Wake up. Open.